Registrar of Court, give us a date.
28th September, my lord. September 28th.
Rule in this matter is called the defendant is not available before the court having been admitted on bail by the magistrate court. This matter is hereby adjourned to the 28th day of September 2023. The matter is for arraignment.
Yes, my lord.
Yes, please call the next case.
All right. FSC/DM/CR/16 2023 between the Federal Republic of Nigeria and Musa Ahmed.
Yes, my lord. We are together.
That is CR what?
CR5? CR16. CR16, 16.
Yes, my lord. We are currently together with the defendant at the correctional center here in Port School.
Registrar of Court, can you hear me?
Yes, my lord.
I said that is CR, is it 05?
16, 16, CR16, yes, my lord.
Okay. Yes.
Respectfully, my lord, my name is Usman Bamala. My humble appearance is for the complainant.
Okay. The matter is for?
It's for sentencing, my lord.
Okay. Thank you, Mala Mustafa.
Thank you, my lord.
Does he have representation, any legal representation?
No legal representation, my lord.
Okay, thank you.
Yes, ma'am.
Sentence.
As the court pleases.
Mustafa, do I read while you interpret to him, or should I just finish reading and then you summarize and interpret?
Yes, my lord. I think it will be the best, my lord.
Okay, thank you.
Thank you, my lord.
On the Mustafa, you can sit if you want. On the 12th day of July 2023, the defendant Musa Ahmed hearing was adjudged guilty of the indictment in the charge sheet dated 8th May and filed 10th May 2023 based on a plea of guilty which he entered when he was arraigned before this court on the 16th day of May 2023. The sentencing was deferred till today to enable me have a deeper reflection on the appropriate sentence which will meet the justice of his case. In criminal jurisprudence, the two broad goals of judicial sentencing are, firstly, to seek to reform the convict so that by the time he completes his penal custodial sentence, which the court imposes, he will return to the society as a better and more responsible citizen who has respect for the laws of the land. The second goal is to impose such sentence as will serve as deterrence to the other persons who are yet to be caught by the proverbial long arm of the law, who are also involved in similar acts for which the convict is being punished. Whilst the first goal focuses on the convict on the dock, the second goal, in my view, focuses on both the convicts in the dock and the society in general, or society at large, especially for persons who are or may be involved in similar criminal activity for which the convict is being sentenced. In relation to the convicts, the sentence the court will impose is to be such as will deter him or her from going back into the same or similar activity as constituting the offense for which he's been punished. Whilst for the other persons out there who are yet to be caught in the web of the law, to persuade them to desist on pain of similar punishment from continuing with or not to go into similar activity. These goals are no doubt largely sociological in nature. In striving to attain both goals, which are really not mutually exclusive, it is the desire of every court of law to strike a delicate balance in order to ensure that the attainment of one goal does not ultimately and invariably lead to the defeat or frustration of the other. In its effort to achieve this, the court takes into consideration a number of factors, and the court, in being able to do this, is required as a baseline to be able to locate the station in life of the convict. By this, the court takes into consideration the attitude of the convict upon his arraignment on the indictment, where a defendant who truly believes and accepts that he was guilty of the allegation in the indictment and readily pleaded guilty upon his arraignment in court, it is part of the factors, as in this instance, which the court is required to take into consideration when imposing its sentence. Quite often, except there are other overriding considerations or extenuating issues, such a convict will be given a discount in terms of his or her sentence. The court is also required, especially in cases involving illicit trafficking in narcotics, to take into consideration the nature of the drugs involved. In this case, it was cannabis sativa that the defendant was convicted of being in unlawful possession of. The provisions of the NDLEA Act stipulates different regime of punishment for unlawful possession of cannabis sativa, in contrast with such other hard drugs and psychotropic substances, such as cocaine or heroin. The court in such cases will consider the quantity found in possession of the defendant when arrested. This enables the court to ascertain whether the defendant is a mere user of hard drugs or is someone who is either a retail or commercial dealer. By considering the quantity of the hard drugs, it enables the court to assess the extent of harm which the defendant has done to himself as a consumer or to the society as a retail or commercial dealer of illicit hard drugs. Again, the location of the arrest of the defendant is an important consideration, because the court will frown at a defendant who attempts to transport hard drugs, e.g. cannabis sativa, cocaine or heroin or controlled drugs, from state to state, as much as one who is selling it in a marketplace or renting a shop and clandestinely in the guise of selling provisions, selling illicit substances. In view of the fact that in either of these two scenarios, the society is at the receiving end, therefore the court will not likely be lenient with such defendants. The court, in relation to a defendant who attempts to transport either hard drugs or controlled drugs, will also be concerned with the mode of concealment. This enables the court to assess the defendant as either an incorrigible dealer or trafficker, or a novice who has only been introduced into the illicit business. The factors which the court will consider are almost inexhaustive, all being in an effort to locate the station of life of the convict in order to impose such punishment as will meet the justice of his case. This is the reason why, in my view, judicial sentencing is perhaps the most important aspect of criminal justice and adjudication process, because it is in this regard that the law comes out real to the defendant and to the larger society. A casual attitude by the court to these issues will invariably lead to the court to impose a sentence or punishment that may be too harsh as to defeat the attainment of the goal to seek to reform the convicts, and which may invariably the attainment of, or even the goal to seek for deterrence in both the convicts and the larger society. Where the sentence is comparably too harsh and out of tune with the realities of the convict station in life, such excessive punishment may eventually well up in the convict a spirit and attitude of indignation, and he will see both the state and its law as rather so unjust. Such a harsh punishment may never appeal to a spirit of remorse or of contrition, as such a convict will bear an unforgivable grudge against both the states, its laws, and its people, and will seek to revenge even after he may have served out the harsh punishment unjustly imposed. On the contrary, where the sentence is too light, the convict takes it as a slap on the wrist, and such comical sentences will never encourage the convict to turn over to a new leaf and be reformed. In view of the fact that trafficking in illicit drugs has been adjudged as a transnational organized economic crime, such a convict, once he has finished his sentence, will readily go back to the same illicit business in the hope that even if he is caught, it is a question of few months incarceration and he'll be released to return to the business and make good money in illicit trafficking in hard drugs. A sentence that is comparatively too light will also not serve as a deterrent to the individuals who are involved in similar criminal activities or deter those who are already contemplating getting involved or being groomed by the drug lords to be used as traffickers for a commission as fees. It is obvious that when this occurs, the court has not discharged its statutory duty well in ensuring that its sentence is one which strikes the delicate balance, which I've briefly analyzed and which are essentially sociological in nature. In my efforts to do this, I took the opportunity to defer this sentence to today to read the extrajudicial statement made by the convict, which was in the court file portion to Section 122 of the Evidence Act 2011. When I read the convict statement, I have the impression of a married man of 30 years who has not really been fully engaged in any productive venture. He has a wife and 3 children. In his extrajudicial statement, the convict stated that he was arrested on the 29th April 2023 when he disembarked from a vehicle from Gamdu to Damaturu with blocks of dried weed concealed inside a blue and white bua sack. He also stated that he bought the exhibit NDLEA Musa 2 from one bana in Gamdu for 45,000 naira, which he divides and ties in wraps and sells each wrap for 100 naira. That this is his second trip to Gamdu town. When I read the case file and the statements volunteered by the convict, I'm left with the impression that in this illicit trade, he is not a novice, even though the prosecution has no previous record of his involvement in this type of crime prior to when he was arrested in April 2023. By the provision of Section 19 of the NDLEA Act, the maximum punishment prescribed by the law, conviction upon conviction, is to be sentenced to imprisonment for not less than 15 years and not exceeding 25 years. However, having regard to the considerations which I had analyzed, the fact that the convict guilty to the charge immediately upon his arraignment on the 16th day of May 2023, and of the fact that he appears remorseful are factors which ought to inform the sentence which this court will pass. Although the quantity of the hard drugs, dry weed, recovered from his possession was 4.4 kilograms, which betrayed him as a commercial dealer. I believe his story that he has been at this nefarious act for 2 years, although this was the first time he has been arrested. Even though the convict mentioned one bana who sells the evil consignment, that is NDLEA Musa 2 to him, I doubt if NDLEA in its investigation went after the said Bana so that he can be apprehended and possibly charged to court. The investigation often conducted by the NDLEA, in my view, is rather too tardy and superficial. And this may be the reason why, despite the incredibly huge convictions which we have judicially recorded, the country's judicial legal system do not seem to be winning the war. Only asked to try and convict their erring boys who are foot soldiers. There are too many loose ends and loopholes in the investigation being conducted by the NDLEA, and it is time it buckle up. Otherwise, all we do here is to hear its cases, nothing more than a sheer waste of precious judicial time and of scarce state resources. In the final analysis, the convict is hereby sentenced to 24 months imprisonment with hard labor. The sentence shall be deemed to have commenced from 29th day of April 2023, when he was arrested by a team of NDLEA officers at Cross Junction, Maiduguri Road, Damaturu, within the jurisdiction of this court. The seized drugs, being cannabis sativa, admitted as exhibit NDLEA Musa 2, and which weigh 4.4 kilograms, is hereby confiscated and shall be forfeited to the federal government of Nigeria. The said exhibit NDLEA Musa 2 shall be destroyed by burning by the NDLEA, along with other judicially condemned narcotics and psychotropic substances at a public function to be organized by the NDLEA. The said event shall be witnessed on NDLEA's invitation by representatives of the Nigerian Police Force, the Department of State Security Service, the Nigerian Security and Civil Defense Corps, as well as the print and electronic media and the general public. This shall be the court sentence of the convict, which I deferred till today in order to reflect deeply on the appropriate sentence. The sentence is no doubt very light. It was deliberately made so in order to encourage the convict to quickly retrace his steps and return to his family, particularly his children. The convict may not be so lucky if in the future is caught and charged for a similar offense. This shall be the court.
As the court pleases, let me affirm myself quickly to interpret to him in summary. I, Mustafa Abana, do solemnly affirm to interpret court proceedings from English to Hausa and vice versa to the best of my ability, so help me God. Musa Ahmed, a takaice yau kotu ta yanke maka hukunci akan wannan laifi da kai wanda aka same ka da tabar wiwi wato kilogram 4.4. An yanke maka shekara 2 wanda zai fara daga 29 ga watan 4 na wannan shekara da muke ciki. A cikin yi maka hukunci akwai hikima kamar haka. Hikima ta farko na yanke ma mai laifi hukunci da kotu take yi shine shi wannan mai laifi ya canja ya zama mutumin kirki, ya shigo cikin al'umma ya zama mutumin kirki. Hikima ta biyu yin hukunci ga mai laifi saboda ya zama izina ga wayanda suke da irin na aikata irin wannan laifi da yasa aka kama shi. Saboda koda wani yana da niyan irin wannan yin laifi, ganin hukuncin da aka yi maka shi ma sai ya ji tsoro ya bari. Baya ga haka nan kotu ta yi maka wannan sassauci sosai a wannan hukunci, kasancewa kai magidanci ne, kana da yara 3 kuma baka da wani kwakwaran sana'a. Kotu kuma ta umarce ka da bayan ka gama zaman ka na gidan yari ka canja ɗabi'anka ka dawo mutumin kirki, kar a sake kama ka da irin wannan ɗabi'a da aka kama ka na sai da barasa. Idan aka kama ka, karancin hukunci da za a yi shekara 10 mafi yawa shekara da doka ta tanadar. A takaice kenan wannan.
Thank you so much, Malam Mustafa, for the interpretation.
Thank you, my lord.
Okay, please, Registry of Court, call the next case.
Yes, my lord. Please, Laku Chambers should mute his gadget, my lord.
Which chamber?
Laku Chambers, my lord.
Mr. Also, please mute your device.
Thank you, my lord.
Yes, go ahead, call the case. Registrar of court, we're waiting. It seems they're having challenges.
Sorry, my lord, can I call the case here in Correctional Center?
Yes, go ahead, please.
Charge number FAC/DM/CR/26/2023 between the Federal Republic of Nigeria versus Makinta Shuaibu. Yes, my lord, we are together with the defendant here in Correctional Center, Kotisku, my lord, waiting for the court sentence.
Respectfully, my lord, my name is Usman Bamala. My humble appearance is for the complainant, my lord. My lord, we are ready, my lord.
Sentence. On the 17th day of July 2023, the defendant, Makinta Shuaibu, hearing was adjudged guilty of the indictments in the charge sheet dated 19th June and filed same date based on a plea of guilty, which he entered when he was arraigned before the court on 5th day of July 2023. The sentence was deferred till today to enable me have a deeper reflection on the appropriate sentence, which will meet the justice of his case. Malam Mustafa, was he around while you were interpreting the proceedings to the last convict?
Yes, no, my lord, he is outside.
Okay.
Yes, my lord.
Okay. Because we have, it's almost the same. Stated earlier, I said in criminal jurisprudence, the true broad goals of judicial sentencing are firstly to seek the reform of the convict so that by the time he completes his penal custodial sentence, which the court imposes, he will return to the society as a better and more responsible citizen who has respect for the laws of the land. The second goal is to impose such sentence as will serve as deterrence to the other persons who are yet to be caught by the proverbial long arm of the law who are involved in similar acts for which the convict is being punished. While the first goal focuses on the convict in the dock, the second goal, in my view, focuses on both the convicts in the dock and the society at large, especially for persons who are or may be involved in similar criminal activity for which the convict is being sentenced. In relation to the convict, the sentence the court will impose is to be such as will deter him or her from going back into the same or similar activity as constituting the offense for which he is being punished. In my efforts to do this, I took the opportunity to defer the sentence, like I stated earlier, till today, to read the extrajudicial statement made by the convict, which was in the court file portion to Section 122 Evidence Act 2011. When I read his statement, I have the impression of a 30-year-old man who has not been fully engaged in any productive venture. He's a motorcycle rider, Okada, who was introduced into smoking dried weed and selling same by one Ibrahim Aya and Saidu in Damaturu, that he used to sell a block per day, which cost 23,000 naira. Also in his statement, the convict stated that he was arrested on the 11th June 2023 while selling his goods, which was confiscated weighing 1.9 kilograms around 1300 hours at Zango Joint, Damaturu. When I read the case file and the statement volunteered by the convict, I'm left with the impression that in this illicit trade, he's not a novice. even though the prosecution had no previous records of his involvement in this type of crime prior to when he was arrested in June 2023. By the provision of Section 19 of the NDLEA Act, the maximum punishment prescribed by the law upon conviction is to be sentenced to imprisonment for not less than 15 years and not exceeding 25 years. However, having regard to the considerations which I had analyzed, the fact that the convicts readily pleaded guilty to the charge immediately upon his arraignment on the 5th of July, 2023, and of the fact that he appears remorseful are factors which ought to inform the sentence which this honorable court will pass. Although the quantity of the dry weights recovered from his possession was 1.9 kilograms, which betrayed him as a commercial dealer, I believe his story that he has been at this nefarious act for years, although this was the first time he has been arrested. Even though the convict mentioned one Ibrahim Aya and one Saidu who sells the evil consignment, that is exhibit NDLEA Makinta 2, to him, I doubt if NDLEA in its investigation went after the said Ibrahim Aya and one Saidu so that they can be apprehended and possibly charged to court. As I stated earlier, the investigation often conducted by the NDLEA is, in my view, rather too tardy and superficial. And this may be the reason why, despite the incredibly huge convictions which we have judicially recorded, the country's judicial legal system do not seem to be winning the war against illicit narcotic trade. The big barrels are left untouched, and the court is only being asked to try and convict their errand boys who are foot soldiers. There are too many loose ends and loopholes in the investigation being conducted by the NDLEA, and it is time it buckle up. Otherwise, all we do here is hear its cases and nothing more than a sheer waste of precious judicial time and scarce state resources. In the final analysis, the convict, Makinta Shuaibu, is hereby sentenced to 20 months imprisonment for both the first and second count. The sentence is to run concurrently. The sentence shall be deemed to have commenced from the 11th day of June 2023, when he was arrested by a team of NDLEA officials at Gashiobadi Town, local government area of Yobe State. The seized drugs being cannabis sativa, dried weeds admitted as exhibit NDLEA Makinta 2, and which weighed 1.9 kilograms is hereby confiscated and shall be forfeited to the federal government of Nigeria. The said exhibit NDLEA Makinta 2 shall be destroyed by burning by the NDLEA, along with other judicially condemned narcotics and psychotropic substances at a public function to be organized by the NDLEA. The said event shall be witnessed on NDLEA's invitation by representatives of the Nigerian Police Force, the Department of State Security Services, the Nigerian Security and Civil Defense Corps, as well as the print and electronic media and the general public. This shall be the court sentence of the convict, which I deferred till today in order to reflect deeply on the appropriate sentence. The sentence is no doubt very light. It was deliberately made so in order to encourage the convict to quickly retrace his steps and return to the society as a changed man, as a reformed person. The convict may not be so lucky in the future if he is caught and charged for a similar offense. This shall be the court sentence.
As the court pleases, kotu ta yanke maka hukunci a wannan laifi da ka aikata. A takaice hukuncin da kotu ta yi maka kamar haka. Dukkan wani wanda aka kama kotu ta yanke ma hukunci, akwai hikima a cikin wannan hukuncin kamar haka guda biyu. Hikima na farko shine saboda shi wanda aka yanke ma hukunci ya zama mutumin kirki, ya canja ɗabi'a, ya shiga cikin al'umma ta gari. Hikima ta biyu shine dukkan al'umma masu irin halaye nashi wanda yasa aka kama shi a wannan laifin, in ma suna yi su gani ya zama darasi a gare su, su daina, su zama mutanen kirki su ma. Saboda haka laifin da ka aikata, karancin ɗauri da doka ta tanadar shine shekara 15, mai yawa kuma shekara 25. Saboda haka kotu ta yi la'akari cewa wannan abu da ka aikata ka yi nadama, kuma wannan ne karo na farko da aka kama ka da irin wannan laifi. Saboda haka kotu ta maka sassauci, ta ɗaure ka wata 20. Wannan ɗauri zai fara daga ranar 11 ga watan 6 na wannan shekara da muke ciki. Kotu ta maka alfarma sosai, wannan ɗauri amma sassauci iyaka shine ɗaurin da aka yi maka kenan. Ka je ka zauna.
Thank you, Madam Mustafa.
Thank you.
Please call the next case.
Charge number FSC/DM/CR/27/2023 between the Federal Republic of Nigeria and Mustafa Maru.
Mustafa Maru, go to him. Yes, my lord, the defendant is currently here with us at the Correctional Center, Potiskum, waiting for the court sentence, my lord. Yau shine ranar da kotu za ta yanke maka hukunci akan wannan shari'a naka da ake yi.
Representation.
Respectfully, my lord, my humble appearance is for the complaint, my lord. We are ready, my lord.
My lord, the defender has no legal representation.
Sentence.
May it please, my lord?
Thank you.
May it please, my lord? May it please, my lord?
Yes.
M.A. Ali, my humble appearance is for the defendant, my lord.
For Mustafa Maru?
Yes, my lord.
I'm sorry, my lord.
Sentence.
Of course, please.
On the 10th day of July 2023, Maru's hearing was adjudged guilty of the indictment in the charge sheet dated 26 June, filed 4th July 2023, based on a plea of guilty, which he entered when he was arraigned before this court on the 5th day of July 2023. The sentence was deferred till today to enable me have a deeper reflection on the appropriate sentence, which will meet the justice of his case. In criminal jurisprudence, the two broad goals of judicial sentencing are firstly to seek the reform of the convict so that by the time he completes the penal custodial sentence, which the court imposes, he will return to the society as a better and more responsible citizen who has respect for the laws of the land. The second goal is to impose such sentence as will serve as deterrence to the other persons who are yet to be caught by the proverbial long arm of the law, who are also involved in similar acts for which the convict is being punished. Whilst the first goal focuses on the convict in the dock, the second goal, in my view, focuses on both the convicts and in the dock and the society at large, especially for persons who are or may be likely or may be involved in similar criminal activity for which the convict is being sentenced. In relation to the convict, the sentence the court will impose is to be such as will deter him from going back into the same similar activity as constituting the offense for which he's been punished. Whilst for the other persons out there who are yet to be caught in the web of the law, to persuade them to desist on pain of similar punishment from continuing with or not to go into similar activity. These goals are no doubt largely sociological in nature, in striving to attain both goals, which are really not mutually exclusive. It is the desire of every court of law to strive in order to ensure that the attainment of one goal does not ultimately and invariably lead to the defeat or frustration of the other. In its efforts to do this, the court takes into consideration the number in life of the convict. By this, the court takes into consideration the attitude of the convict upon his arraignment, where a defendant who truly believes and accepts Hello, good morning.
Good morning, my lord.
Good morning.
Morning, my lord.
Hear me?
Yes, we can hear you, my lord.
Can you hear me?
Yes, my lord.
Hello, can you hear me?
Yes, we can hear you, my lord.
Okay, I'm so sorry. I was offline for some time.
Yes, my lord.
Wannan shine sakataren malar. Shi wannan Usman. Shi wancan belief ne. Belief ne goma. Wannan shine sakataren malar. Wannan da ya. Wannan to ya dauke ya zama.
Good morning once again.
Morning, my lords.
I'm so sorry. It seems today I'm having challenges, but I've changed my browser, my router, so maybe, okay. That case is Makinta Shaibu.
Yes, my lord. Makinta Shaibu.
Mustafa Maru.
Mustafa Maru.
I meant to say Mustafa Maru.
Mustafa Maru.
Okay. Yes, when I read the convict statement, I have the impression of a young man of 27 years who has engaged himself in a productive venture after primary school. Let me have it. Thank you. Okay. I said, when I read the convict statement, I have the impression of a young man of 27 years who has engaged himself in a productive venture after primary and secondary schools by working at his brother's chemist. That one Mohammed introduced him to one Sani at Lagos who sends or transports tramadol to the convict forward to the said Sani's customers at Niger Republic, that he communicates with both Sani and the customers through the same telephone number, whereby he is usually paid 2,000 naira. That on the 14th June 2023, the said Sani called him to go and collect a message, to which the convict sends one Maru Mustafa to collect on his behalf, as he was busy, and also handed his phone to Maru Mustafa to call Sani's number when he collects the message. Whereupon the said Maru Mustafa was arrested by the NDLEA, and the convict Mustafa Maru Trust, and also arrested by the NDLEA. The convict confirmed to the NDLEA that Maru Mustafa knows nothing about the contents of the message, and he was set free. When I read the case file and statements volunteered by the convicts, I'm left with the impression that in this illicit trade, he's not such a novice, but is being used as a pawn or a courier by the unidentified Sani. The convict has not stated for how long he has been involved in this type of crime prior to when he was arrested in June 2023. By the provision of Section 11 of the NDLEA Act, SOPRA, the maximum punishment prescribed by the law upon conviction is to be sentenced to imprisonment for a term not less than 15 years and not exceeding 25 years. However, having regard to the considerations which are analyzed, the fact that the convict pleaded guilty to the charge immediately upon his arraignment on the 15th day of July 2023, and of the fact that he appears remorseful are factors which ought to inform the sentence which this court will pass. Although the quantity of the hard drugs, that the tramadol sachets recovered from his possession was 1.5 kilograms, which puts him in the category of commercial dealers. I believe his story that he has been at this nefarious act for some time. This was the first time he has been arrested, even though the convict mentioned one Sani who settles or pays him with the flimsy amount of 2,000 naira. It is obvious that the convict is not selling the evil consignments, that is exhibit NDLEA Mustafa 2. As noted earlier, he was used as a pawn to forward the exhibit and even distribute same to the said unidentified Chinese customers in Niger Republic. I doubt if NDLEA in its investigation went after the said Sani so that he can be apprehended and possibly charged to court. The contents of the extrajudicial statements of the convict shows that the convict knows the said Sani so well and whom assists with 2,000 Naira settlement of commission fees. The convict stated that he has Sanis as well as the customer's phone numbers. Did the NDLEA make any attempt to track down either the owner Sani or the said people billed to receive exhibit NDLEA Mustafa in Niger Republic? There are too many loose ends and loopholes in the investigation being conducted by the NDLEA, and it is time it buckle up. Otherwise, all we do here is hear its cases and nothing more than a sheer waste of precious judicial time and waste of scarce state resources. In the final analysis, the convict is hereby sentenced to 15 months imprisonment. The sentence shall be deemed to have commenced from the 17th day of May, 2023, when arrested in the course of follow-up operations by NDLEA officers dealing in 1.5 kilograms of tramadol along Damaturu Gedam Road, Damaturu Yobe State, within the jurisdiction of this honorable court. The seized drugs being tramadol tablets admitted as exhibit Mustafa 2, and which weighed 1.5 kilograms, is hereby confiscated and shall be forfeited to the federal government of Nigeria. The said exhibit Mustafa 2 shall be destroyed by burning by the NDLEA along with other judicially condemned narcotics and psychotropic substances at a public function to be organized by the NDLEA. The said event shall be witnessed on NDLEA's invitation by representatives of the Nigerian Police Force, the Department of State Security Service, and the Nigerian Security and Civil Defense Corps, as well as the print and electronic media and the general public. This shall be the court sentence, which I deferred till today. The sentence is no doubt very light. It was deliberately made so in order to encourage the convict to quickly retrace his steps and return to the society as a reformed person. The convict may not be so lucky if he is caught and charged for a similar offense next time. This shall be the court sentence.
As the court pleases. Maru a takaice duk da kana da lauya, amma bari in fassara maka wannan hukuncin wannan kotu da aka yanke maka. A takaice kotu ta yi la'akari cewa kai matashi ne, shekarunka 27. Kuma wannan ne karo na farko da aka kama ka da wannan abu aka kawo ka har gaban hukumar shari'a kenan. Saboda haka kotu ta umarce ka ta ɗaure ka ainihin wata 15. Zai fara ne daga ainihin ranar 17 ga watan 5 na shekarar nan da muke ciki. Saboda haka kotu ta umarce ka da karka sake aikata irin laifi irin wannan haka. In ya kasance an sake kama ka, kaɗan daga cikin hukuncin da doka ta tanadar shekara 15 ne ɗaurin, mafi yawa kuma shekara 25. Saboda haka ka kiyaye, in ka gama zaman gidan yari ka fita ka zama mutumin kirki, ka canja rayuwanka da ɗabi'arka. Shine a takaice.
Thank you, Madam Mustafa.
I am much more grateful, my Lord, for the sound and eloquent judgment. May it please, my Lord. Thank you.
Thank you, Counsel. Yeah. Call the next case, please.
Charge number FSC/DM/CR/9/2023 in the Federal Republic of Nigeria and An-Nur Mustafa.
An-Nur Mustafa, sorry. An-Nur Mustafa. An-Nur Mustafa. An-Nur Mustafa. Yes, my lord. The defendant is here in Correctional Center, Fortiskum, my lord.
Yes. Presentation, please.
Respectfully, my lord, my name is Usman Bamala. My humble appearance is for the complainant. My lord, we are ready to listen for the sentence, my lord.
Yes, my lord. The defendant has no legal representation.
Yes, thank you. Sentence.
As the court
On the 16th day of March 2023, the defendant hearing was adjudged, and Noor Mustafa was adjudged guilty of the indictment in the charge sheet dated 31st January 2023 and filed 9th February 2023 based on a plea of guilty, which he entered when he was arraigned before this honorable court on the 16th day of May 2023. The sentence was deferred to today to enable me have a deeper reflection on the appropriate sentence, which will meet the justice of his case. In relation to the convict, the sentence the court will impose is to be such as will deter him from going back into the same similar activity or constituting the offense for which he's been punished. By this, the court takes into consideration the attitude of the convict upon his arraignment on the indictment, where a defendant who truly believes and accepts that he's guilty of the allegation in the indictment and readily pleaded guilty upon his arraignment in court, it is part of the factors, as in this case, in this instance, which the court is required to take into consideration when imposing its sentence, quite often accepts there are other overriding considerations or extenuating issues. Such a convict will be given a discount in terms of his or her sentence. The court is also required, especially in cases involving illicit trafficking in narcotics, to take into consideration the nature of the drugs involved. In this case, it was nitrazepam and tramadol tablets, all psychotropic substances that the defendant was convicted of being in unlawful possession with. The provisions of the NDLEA supra stipulates different regime of punishment for unlawful possession of cannabis sativa or hard drugs, in contrast with other psychotropic substances such as cocaine or heroin. The court in such cases will consider the quantity found in possession of the defendant when arrested. This enables the court to ascertain whether the defendant is a mere user or abuser of hard drugs, or is someone who is either a retail or commercial dealer. By considering the quantity of the hard drugs, it enables the court to assess the extent of harm which the defendant has done, has done to himself or as a consumer, or to the society as a retail or commercial dealer of illicit hard drugs. Again, the location of the arrest of the defendant is an important consideration, because the court will frown at a defendant who attempts to transport hard drugs, cocaine or heroin or controlled drugs from state to state, as much as one who is selling it. In a marketplace or renting a shop and clandestinely in the guise of selling provisions, selling illicit substances. In view of the fact that in either of these two scenarios, the society is at the receiving end. Therefore, the court will not likely be lenient with such defendants or convicts. The court, in relation to a defendant who attempts to transport either hard drugs or controlled drugs, will also be concerned with the mode of concealment. This enables the court to assess the defendant as either an incorrigible dealer or trafficker, or a novice who has only been introduced into the illicit business. The factors which the court will consider are almost inexhaustive, all being in an effort to locate the station of life of the convict in order to impose such sentence as will meet the justice of his case. This is the reason why, in my view, judicial sentencing is perhaps the most important aspect of criminal justice and adjudication process, because it is in this regard that the law comes out real to the defendant and to the larger society. A casual attitude by the court to these issues will invariably lead the court to impose a sentence punishment that may be too harsh as to defeat the attainment of the goal to seek the reform of the convict, and which may invariably impair the attainment of even the goal to seek for deterrence in both the convict and the larger society. Where the sentence is too harsh, and out of tune with the realities of the convict's station in life, such excessive punishment may eventually well up in the convict's spirit and excuse me.
Sorry, man.
Hello, good morning.
Morning, man.
Okay, I'm sorry, I had a little bit of a health challenge. In the final analysis, the convict is hereby sentenced to 4 years imprisonment with hard labor. The sentence shall be deemed to have commenced from the 10th day of January 2023, when he was arrested by a team of NDLEA officers in the course of stop and search operations along Potiskum Damaturu Road, Yobe State.
Has the court ruled?
It says drugs being 7.8 kilograms of nitrazepam and 1 kilogram of tramadol tablets, all psychotropic substances, admitted as exhibit NDLEA and NUR 4A and 4B, weighing 7.8 kilograms and 1 kilogram respectively, confiscated and shall be forfeited to the federal government of Nigeria and shall be destroyed by burning by NDLEA. This shall be the court sentence of the convict, which I deferred till today. It was deliberately, sentence is now down very light. It was deliberately made so in order to encourage the convict to retrace his steps and return to the society as a reformed person. The convict may not be so lucky if in future is caught and charged for a similar offense.
Levido dim national so ordinary. Asunumana uko di ngiro au hukuncin kamina. Asunumana so levido dimashima ari. Levi zoro zo. Ganado sorojoron ze de sami wuri. Awado kaya gulzina. Ngunzu safindi luko. Levido shima do dimado. Annan karo kodi nya shimrama nguzu nyari gana tadana. Rajrebi sanum gana. Wani na au prison arjim lumia lenum kam glamar wallum allamiya sami. Annan karo kodi nya sa indiro sirina. Sa indiyar yim kawume kuntaw janairu sa adiyan badijin. Annan karo kodi ngiro zo maro nya ngiro rama sunna. Na sa indide sa indiron ya cero kun tawo findi de rike asuma na
Mustafa is 4 years. 4 years.
4 years.
Yeah.
It's
4 years.
Okay.
4 years.
Sa dieuron ya cero asuma na kodin ya sa dieuro serina yimdo badijin dukuri yimdo kun tawo janairu ya kwanna hada kawun zumewa badijin asuma na annan kado ko da teda zan yuro rama sunna case nam Allah so annan kado hal nim ya sai wai ta monum lumiya kam gala mar walle da ne sanyan gala nya banajin mamani de asun mana da ne namni
So the next case.
Next case Ibrahim Isiaku.
Charge number FSC/DM/CR/13 2023 between the Federal Republic of Nigeria and Ibrahim Isiaku.
Yes, my lord. We are together with the defendant at Correctional Center here in Portisco.
Thank you,
My lord, my name is Usman Bamala. My humble appearance is for the complainant. My lord, the matter is fixed today for review of fact, subject to the convenience of my lord. We are ready to proceed, my lord.
Go ahead.
My lord, I intend to review the fact of this case through Mr. Bablu David, who is the exhibit officer, my lord, in this case.
Yes, my lords. We are together with PW here in person of Baburu David, and he is ready to affirm himself, my lord.
Yes, go ahead.
I, Baburu David, do solemnly affirm to state that the evidence I give in this case before this honorable court shall be the truth, the whole truth, nothing but the truth, so help me God.
Yes, my lord. PW1 has affirmed himself. He is male, adult, and a Muslim, my lord.
PW1, a Muslim?
Yes, no, sorry, my lord, he's a Christian. Male, adult, and a Christian.
Yes. Okay.
Mr. Babulu David.
Yes, my lord.
Please tell this honorable court, what do you do for a living, and what are your schedules of duties, and what do you know about this case as against the defendant in respect of this case? Very briefly, please.
My lord, I work with the National Drug Law Enforcement Agency, Yobe State Command. I'm a public servant. And my schedule of duty are?
Just a minute. Madam Mustafa, you need to
Madam.
interpret to the defendant.
As the court, please. As the court,
Yes,
please.
the witness can sit down if there's a seat there.
Okay, my lord. My lord, you can sit there.
Yes.
Wannan shine mai bada shaida akan ka mutum na farko kenan wannan. Sunansa Bagudu David, ma'aikaci ne na NDLEA.
Yes, go ahead.
My schedule of duty are receiving suspects and the SB recover from them, carry out a field test of the recovered exhibit, weighing of the exhibit recovered from the suspect, issuing exhibit form for suspect to sign, arresting officer also to sign, my lord, testify in court when the need arise regarding our exhibit case in my custody, taking the drugs exhibit, that is the forensic A1 to Lagos for forensic analysis, my lord.
Kaɗan daga cikin ayyukansa ya ce, ya shafi ajiye dukkan kaya da aka kama wato kayan doka a wajen wanda ake zargi aka kama, kuma yana gwadawa akwai ƙwarya-ƙwaryen gwaji da suke yi kafin su aika Lagos wajen yin gwajin ƙwararru. Wannan ƙwarya-ƙwaryen gwajin da yake yi shi ma yana daga cikin aikinsa, da kuma dukkan wani aiki wanda shugaban shi zai sa shi. Wannan irin nau'in aikinsa kenan da ya faɗa mu kotu.
My lord, on the 14th days of February 2023, the defendant was brought before me in my office along with the along with a bag. Ghana must go back by two of the officers, Musa Abdullahi and Abba Zakaria. I opened the bag in the presence of the defender and the witness officer. I discovered that it was dry weed suspected to be cannabis sativa and diazepam tablet suspected to be psychotropic substance, my lord. I carried out a field test of the recovered exhibit, and the test proved positive for cannabis sativa and positive for diazepam. And the weight of the cannabis was 24 kilograms, my lord, and that of diazepam was 160 grams, my lord.
Ya ce a ranar 14 ga watan Fabrairu da ya gabata na shekarar nan, ma'aikatansu guda biyu sun kawo ka wajen tare da jaka na Ghana Masgo. Da aka bude sai aka tada busasshen ganye ne wanda ake zargin tabar wiwi ce da kuma kwaya na diazepam a ciki. Wanda ya yi kwarya-kwaryen gwaji sai tabbatar cewa wannan busasshen ganyen tabar wiwi ce, wannan kwayan kuma diazepam ce. Da ya gwada nauyinsa shi wannan busasshen ganye ya bada kilogram 24, shi kuma wannan kwaya ya bada gram 160.
Just later, I brought an exhibit form, namely certificates of test analysis, packing of substance form, request for scientific aid form, and wire transparent evidence form. I filled the necessary columns. The arresting and the witness officer order filled their column, and the suspect signed and completed on the form, my lord.
Baya ga haka ya kasance sai ya ciro wasu takardu nasu da ake ciccikewa na bada shaida ne wannan takardun. Ya ciccike DS din da ya kamata ya sa hannu ya sa hannu, wannan wanda suka kama ka da mai bada shaida su biyun nan su ma suka cike guraben da za su cike, kai ma sai ka sa hannu ka dangwala akan wannan takardu.
I took some quantity of dry weed and diazepam and put in the wire transparent evidence forms, my lord. And where the book and the exhibit, I kept it, the exhibit room for safekeeping. And on the 11th of April 2023, I took the sample to NDA lab in Lagos for forensic analysis, my lord. And I received the result on the 12th of April 2023.
Ya ce bayan nan sai dan ɗebi kaɗan daga cikin busasshen ganyen nan da kuma kaɗan daga cikin ƙwayan nan sai ya tura a garin Lagos saboda a je a yi gwaji na ƙwararru a kai a tabbatar cewa abin da ake zargin ne. Ranar 11 ga watan 4 da ya gabata kenan. Washe gari ranar 12 sai ya samu sakamakon wannan gwaji da aka yi aka turo masa shi.
Thank you.
Mr. Bagul David.
Yes, my lord.
In the course of your testimony before this honorable court, you made mention that you filled some exhibit forms in which you signed, the witnessing officers and the arresting officer also countersigned, and the defendant also affixed his thumbprint on the state exhibit forms.
Yes, my lord.
You further stated that on the 12th day of, on the 11th day of May, you took sample of the said exhibit and you received a response on the 12th May 2023. April, whereby the said result was sent to you, calling your attention. Attached to the said drug analysis report is a brown envelope.
Yes, my lord.
Am I correct?
Yes, my lord.
You further stated that you kept the bulk of exhibits before this for safekeeping at your own custody.
Yes, my lord.
Thank you very much. Tell this honorable court how you'll be able to identify the said exhibit forms together with the said drug analysis report, the brown envelope, and the said bulk of exhibit before this honorable court. Thank you.
My lord, on the exhibit form, the name of defender is written. Also my name, my signature, and the date of the documentation. Well, on the forensic results, the date I received the result, and I calling my attention and the NDLA case file number And the book at the exhibit, the name of defendants is also written on the back, the NDLA case file number, the weight of the exhibit, and the date of documentation, my lord.
My lord, we apply to show the witness the said purported documents, my lord, for identification.
Go ahead.
Shi mai gabatar da ƙara ya tambayi mai bada shaida ya ce akwai kamar yadda an bata a bada shaidansa ya ce akwai wasu takardu da ya ciccika ya sa hannu kai ma ka sa hannu duka dai kamar yadda aka faɗa da farko ta yaya zai shaida wannan takardun ya ce akwai sa hannunsa a kai kai ma akwai sa hannunka wa'inda suka bada shaida da wanda ya kama ka duk akwai sa hannunsu a kai shi kuma wannan kaya da aka kama a wurinka ya ce akwai sunanka a rubuce a jiki da sunan kayan da kuma ainihin wato yawansa da aka gwada duk a rubuce a jiki ta nan ne zai shaida.
My lord, we equally apply for the witness to open the said brown envelope to ascertain what it contains, my lord.
Yes, application granted.
Ya sake da ba da dama a buɗe wannan sakamako da aka karɓo daga Lagos a tabbatar da gwajin da aka yi din a gani kotu ta ba da izinin yin hakan.
My lord, this is the remnant of the forensic analysis, both the the cannabis sativa and the diazepam tablet, my lord.
Okay.
My lord, we equally apply for the witness, my lord, to bring forward the said bulk of exhibit, my lord, for identification, my lord.
Ya sake kotu ta ba da dama mana a kawo wannan kaya da aka kama ka da shi saboda a tabbatar cewa ita ce a gani.
Let's go ahead.
Here's the book of the exhibit, my lord.
Yes.
My lord, we apply for the witness to open the said bulk of exhibit.
Yes, go ahead, please.
Na buƙaci kotu ta ba shi dama ya buɗe ainihin wannan jakan a duba.
There's a block, compressed gloss wrapped in the yellow sellotape, my lord. But some of the block were affected by the wood, my lord.
Just a minute. I can see the compressed blocks wrapped in yellow sellotape, and then
Some of them we are affected by the rodent, my lord. But
rats, rodents.
yes, sir. Yes, my lord.
How many blocks?
27 blocks, my lord.
Can you ascertain?
Okay, my lord. And that is the diazepam tablet, my lord. What considered of the white plastic. Transparent. Yes.
Okay. The block of compressed blocks, how many?
27, my lord.
27.
Yes, my lord.
I want you to ascertain. You are handing it over to the court.
Okay.
Or you may put it on this table. Okay.
This
The loose particles.
yes, the loose quantity affected by the
Okay.
gluten.
Okay. Yes.
Consequently, my lord, we apply to tender the packing of the substance form, certificate of the test analysis, the request for scientific aid form, the drug analysis report, the brown envelope together with the transparent port ballot containing the remnant of the exhibits and the bulk of exhibit ballot in evidence before this honorable court.
Can you return the bulk, the exhibits inside the backpack sack?
Okay, covered basis.
Christopher,
My lord,
you have ascertained that you have 27 pieces there?
yes, my lord.
Okay, thank you. The following exhibits are hereby admitted into evidence. The exhibit forms comprising of A, certificate of test analysis form, B, packing of substance form, C, request for scientific aid form, hereby marked as NDLEA Ibrahim 1A, 1B, and 1C respectively. While the white transparent evidence pouch with the analyzed exhibit of both the cannabis sativa and the diazepam tablets as NDLEA exhibit Ibrahim 2A and 2B respectively. The drug analysis report as exhibit NDLEA Ibrahim 3, the brown envelope as NDLEA Ibrahim 3A, the brown envelope as NDLEA Ibrahim 3B. The bulk of the exhibit of compressed blocks wrapped in yellow sellotape concealed inside a white Ghana must go sack, marked as NDLEA Ibrahim 4A, and the diazepam tablets concealed in white plastic, concealed in a transparent pouch in a white plastic as NDLEA Ibrahim 4B respectively.
Let's go, please. My Lord, that's all for the examination chief.
Kotu yanzu ta karbi waɗannan takardu da aka ciccika, wanda ka sa hannu shine gabatar da mai bada shaida ya sa hannu, da kuma gwaji da aka je aka yi a Lagos, da kuma wannan kaya da aka kama da wajen ka wiwi da kuma diazepam. Duka kotu ta karba a matsayin shaida a kanka wajen yanke maka hukunci.
Ask the defendant whether he has any questions to ask the exhibit officer.
As the court pleases. Kana da tambaya da za ka yi wanda ya bada shaida a kankan nan? He has no question, my lord.
My Lord, that's all for.
Yes, just a minute. Show the defendant the exhibits and ask him whether this were the ones recovered from his possession when he was arrested.
As the court pleases. Wannan takardu da aka sa hannu wanda kai ma ka dangwala shi mai bada shaida ya sa hannu, da waɗanda suka kama ka suka kawo ka duka suka sa hannu, da kuma wannan sakamakon gwaji da aka turo daga Lagos, da wannan duka shine sakamakon wanda aka yi gwaji a kai, da kuma wannan wiwi wanda aka kirga ta yanzu da kwayar da ya zafam da aka kama a ciki, dukkan ya tabbatar da gaskiyar zargi da ake maka akan wannan shari'a da ake yi.
Okay.
He admitted, my lord.
Yes, counsel.
My Lord, that's all for the review of fact through the exhibit officer. My Lord, we apply for the exhibit officer to be discharged from the witness box, my Lord.
Application granted. Thank you, officer.
As the court pleases.
My Lord, we equally apply for the court to convict the defendant as charged.
Then Mustafa asked the convict whether the facts as presented by as stated by the prosecuting counsel and the exhibits as presented by the exhibit keeper, as well as the statements presented by the NDLEA officer reflect the true position of the case.
As the court pleases, dukkan waɗannan shaidu a wannan takardu da aka gabatar a kotu, wanda kotu ta karba a matsayin shaida a kanka, da wannan su gwaji da aka yi, da su wannan wiwi da kuma da yazafan da aka kama a wurinka, da kuma shi wanda ya bada shaida a kanka wato Mr. Bagudu, ya tabbatar da gaskiyan lamari da ake kawo ka kotun nan, wato ma'ana shari'a tuhuma da ake maka, ya tabbatar da gaskiyan tuhuma da ake maka a wannan kotu. Ka daga murya. Ya tabbatar. Yeah, admitted, my lord.
Whether the defendant has any cause to show why he should not be convicted as charged.
As the court pleases, kasancewa duka ka tabbatar ka amince, kana da wani dalili da zaka faɗa ma kotu wanda zai hana a hukunta ka? You say no, my lord.
The defendant, who is not literate in English language, had the charge read and interpreted to him through a sworn interpreter. He pleaded guilty to the charge. The learned prosecutor consequently indicated his intention to conduct a review of the facts of the charge. This was an exercise which is peculiar to drugs and related offenses and was not meant to require the prosecution to prove the allegation in a criminal charge which the accused person had voluntarily pleaded guilty to. By the provision of the law, except in capital offenses, once a defendant had pleaded guilty to an indictable felony punishable with a term of imprisonment, the court is empowered, especially in relation to the Federal High Court, who by section 33, sub 2 of its enabling act, cap F12 laws of the Federation of Nigeria, 2004, empowered to try criminal cases and matters summarily, to proceed to convict the defendant. The exercise to do a review of the facts of the charge was consequently done now. I've listened to the learned prosecutor, Usman Bamala Esquire, who has produced certain documentary and real exhibits which have been admitted in evidence. Exhibits Ibrahim, NDLEA Ibrahim 1B, 4A and B being the bulk of the exhibits seized and recovered from the defendant. It's one of the hard drugs which the extant legislation, that is the National Drug Law Enforcement Agency Act cap FN 30 laws of the Federation of Nigeria 2004 has outrightly, except where lawful authority is shown, prohibited its sale, possession, and or consumption. The defendant, Ibrahim Isiaku, who on arraignment pleaded guilty to the charge, has not produced any evidence of lawful possession of exhibits. NDLEA Mustafa 4A and 4B, I'm satisfied against his plea of guilty and the field-tested proofs of exhibits 1A, 1B, 1C, 2A, 2B, that the case against the defendant has been proved beyond reasonable doubt as is required by sections 137 and 138 of the Evidence Act. In view of the plea of guilty entered by the defendant and in line with the provisions of sections 2741 and 2 and 3561 and 2 of the Administration of Criminal Justice Act 2015, this court hereby finds the defendant, Ibrahim Isiaku, guilty of knowingly without lawful authority found and arrested with dealing in narcotics and psychotropic substances, similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under section 19 of the NDLEA Act, cap N30 laws of the Federation. The defendant, Ibrahim Isiaku, is hereby found guilty and convicted as charged. I shall listen to the allocators of the convict before I pronounce on his sentence. This shall be the judgment of this court on the basis of the charge.
Yes. Ibrahim Isiaku a takaice da duba da ainihin hujjoji da mai gabatar da kara ya gabatar a gaban kotu, wanda ya hada da kiran shaida wanda ya bada shaida a kanka da kuma wannan takardu da aka gabatar da ma wannan wiwi da aka kama ka da kwaya duka ya tabbatar cewa kotu ta gamsu cewa yanzu kai mai laifi ne, saboda haka kotu ta kama ka da laifi, kai yanzu ka kasance mai laifi. So yanzu kotu za ta shaurara ta ji daga wurinka wani alfarma za ka nema a wajen wannan kotu kafin ta yanke ma hukunci.
Any record of previous conviction?
Well, the convict has no previous record of conviction.
Kotu tana so ta ji daga wajenka wani alfarma za ka nema, sai ka daga murya kai magana.
And my lord, the convict was arrested since the second day of this year, my lord, that's February. Since February, sometimes in 14th day of February 2023, my lord. My lord, he confessed the commission of the crime right from investigation without wasting the time of investigation. I urge this honorable court to consider the stated fact as part of mitigating factor. My lord, as part of aggravating factor, the convict, my lord, transport the exhibit from another jurisdiction, my lord, to your state, my lord. My lord, these are my humble facts that I urge this honorable court to consider. Thank you.
Shi mai gabatar da ƙara ya gaya ma kotu cewa kai an kama ka ne tun ranar 14 ga watan biyu na wannan shekara, kuma da aka kama ka ba ka da wani laifi da ya nuna ba taba kama ka da irin wannan laifi ba, kuma a wajen bincike baka bata lokaci ba, ka amince cewa ka aikata wannan laifi, kuma shi mai gabatar da kora ya tabbatar ma kotu haka akan cewa ba taba samun ka da irin wannan laifi ba, kuma baka ba su wahala wajen yin bincike ba, kuma daɗin daɗawa kai wannan kaya wiwi da taba da ainihin kwaya ka ɗauko su ne daga wata jiha ka kawo ta nan jihar Yobe. Dukkan abin da ya faɗa ma kotu kenan.
Does he have anything to say to the court, the convict?
Kana da wani, as the court please, kana da wani abu da za ka faɗa ma kotu? Ka ɗaga murya a jika. Yi magana.
Ina roƙon kotu mai alfarma. Da ina da nauyi da yawa a kaina.
Ka yi magana, ka ɗaga murya.
Ina roƙon kotu mai alfarma da sassauta mun. Ina da nauyi da yawa a kaina, da mahaifiyata, da matana, da yarana. Kuma wannan kaya da aka kama ni da shi.
Yes.
Ci gaba.
Wannan kaya da aka kama ni da shi ba asalin nawa ba ne. An aiko min ne, na zo na karɓa. Zan kai yi wa mai shi.
Ci gaba.
Shi wannan kaya da aka kama ni da shi an aiko min ne, na je Kano na karɓa, ina kan hanya na dawowa sai aka same shi a gona, don a lokacin da aka samu ban san ma menene na ɗauko ba. Dan lokacin da aka kama ni, wanda suka kama ni har sun kama wani daban sun samu ranko a hannunsa. Sai na fito lokacin ina gengedi, na fito sai nake gaya musu cewa wannan ai jakata ce.
Yes.
Ci gaba.
In ki gaya musu wannan jakata ce, ya ce wannan ta ce, in ce marta ce. Sai ce ka san me yake cikin, ce marta.
Malam Mustafa, not explanations. What does he want the court?
Kawai ka takaita, ba wai labarin abin da ya faru za ka gaya ma kotu ba. A yanzu matakin nan.
Ina neman alfarmanin kotu mai adalci da ta sassauta mu. Ina da mahaifiya wanda ke ɗaukar nauyinta, da ƙannena, mahaifina ya rasu, ina da mata da yara. Ina neman kotu ta sassauta mu.
Kotu ta ce.
What does he do for a living?
Me sana'arka?
Ni ina sai da shinkafa da mai da ƙarago.
Shinkafa da mai da ƙarago?
Da ƙarago ba?
Is that cooked or uncooked?
Shinkafan da fefe ne ko ba da fefe ba?
Ba da fefe ba ne.
What led you into this business?
Yaushe ka shiga wannan sana'a?
Why? What led him to it?
Me yasa ka shiga wannan sana'a?
Wannan sana'a? Wannan sana'ar kayan ba na bane. Amma dai ina neman sauki ne yasa na amsa a matsayin na saboda ba yadda zan yi in iya kawo mishi.
Why? Me yasa ba za ka iya kawo mai shi ba?
Saboda ya riga ya gudu kuma ni ina hannu. Wanda ya tura kayan ba? Wanda zan ba din aiki na so a kama. Kuma ya ji labari an kama ya gudu shi. Na yi bayani tun a lokacin da aka kama ni. A statement ɗina ma a rubuce a kan.
Is it not part of the? It's not part of it. It's not part of it.
Ruling.
As God pleases.
On the 14th day of March 2023, the defendant, Ibrahim Isiaku Herin, was adjudged guilty of the indictment in the charge sheet dated 28 February and filed 6 March based on a plea of guilty, which he entered when he was arraigned before this court on 14th day of March 2023. The sentencing was deferred a number of times because the defendant, the convict was not produced from the correctional center. Thankfully, today, the proceedings by virtual method, the prosecuting counsel as well as the court registry are at the correctional center, Patti School Correctional Center. Now, having listened to the defendant, I asked the defendant a number of questions to find the location of the of the defendant, of the convict, wanted to understand his station in life. I believe the story that he has just told me. In the final analysis, the convict is sentenced to 4 years imprisonment for the second counts, 6 months imprisonment for the third and fourth counts. The sentencing is to run concurrently. The sentence shall be deemed to have commenced from the 14th day of February 2023, when he was arrested by a team of NDLEA officers in the course of patrol operations along Guru Kano Road, Guru Yobe State, within the jurisdiction of this court. The seized drugs being admitted as exhibits is hereby confiscated and shall be forfeited to the federal government of Nigeria. The state exhibit shall be destroyed by the NDLEA by burning, along with other judicially condemned narcotics and psychotropic substances, at a public function to be organized by the NDLEA, which shall be witnessed on NDLEA's invitation by representatives of the police, Department of DSS, Nigerian Security and Civil Defense Corps, as well as the print and electronic media and the general public. This shall be the court sentence of the convict, which I deferred till today.
I'm sorry, my lord. The sentence will take effect from when, my lord? Sorry, my lord. We cannot hear you.
I said, can you hear me now?
Yes, we can hear you now, my lord.
The sentence shall be deemed to have commenced from the 14th day of February 2023, when he was arrested by a team of NDLEA officers.
As the court pleases. As the court pleases.
I said the sentence is no doubt very light. It was deliberately made so in order
First and second count 4 years. The third and fourth
offense.
6 years. Concurrently. As the court pleases. Brian, duba da laifin da ka aikata, kotu ta yanke maka hukunci kamar haka. Dama tuhuma da ake maka tuhuma ne daban-daban har guda 4. So wajen yanke ma hukunci a tuhuma ta farko da na biyu, kotu ta yanke maka shekara 4. A tuhuma ta 3 da na 4, kotu ta yanke maka shekara 6. Wanda
no, it's 6. Mustafa is 6 months.
6 months.
Yes.
6 months. Sorry. That and for 6 months. Shi tuhuma na 3 da na 4 an daure ka wata 6, wanda wannan dauri za su tafi tare duka. Ka fahimta? Saboda haka nan kotu ta yi maka sassauci a wannan hukunci da aka maka, duba da shekarun da doka ta tanadar, inda asalin abin da doka ta tanadar za a daure ka mafi karanci shine shekara 15. Mafi karanci kenan dauri a irin wannan laifi. Mafi yawa kuma shekara 25. Saboda haka kotu ta yi la'akari da cewa kai magidanci, kai kake ɗaukan ɗawainiyan gidanka da ma iyaye duka. Kotu ta yi la'akari da wannan duka. Da kuma shaidan da shi mai gabatar da ƙara ya baiwa a gaban kotu cewa baka ba da wahala wajen yin bincike ba. So shi ne.
Thank you. Please call the next case.
Call the next case. Go.
Charge number FSC/DM/CR/21 2023 between the Federal Republic of Nigeria and Suleiman Bulama.
Suleiman Bulama. Yes, my lords, the defendant is here present at the Correctional Center, Potiskum, my lords.
Thank you.
Respectfully, my lord, my name is Usman Bamara. My humble appearance is for complainant. My lord, the matter is fixed today for review of fact, subject to the convenience of my lord. We are ready, my lord. My lord, I intend to review the fact of this case through the 2IC exhibit, Mr. Rabiu Muhammad Suleiman. With the
Let's
leave
go
of this,
ahead.
thank you very much.
Yes, my lord, PW1 is here present at the Correctional Center, Potiskum, and he is ready to affirm himself.
Yes, go ahead.
I, Mohammed Rabi Suleiman, do solemnly affirm that the evidence I shall give in this case before this honorable court shall be the truth, nothing but the truth, so help me God.
Yes, my lord, PW1 has affirmed himself. He is male, adult, and a Muslim, my lord. Wannan shine zai bada shaida akan.
You can have a seat if you wish to.
No, I think not. Thank you, madam.
My lord, Mr. Rabiu Muhammad Suleiman, please tell this honorable court, what do you do for a living, what rank did you attend, and what are your schedules of duties? And tell this honorable court very briefly, what do you know about the defendant, considering the fact that he has pleaded guilty in this matter?
I work with the National Drug Law Enforcement Agency, Government State Command. I'm a chief narcotic agent. My schedule of duties are receiving of suspect and the exhibit recovered from them, carrying out a field test on the recovered exhibit, weighing and issuing of exhibit forms for the suspect to thumbprint, witnessing and arresting officer also to fill their columns, keeping an entry of the bulk of the exhibit for safekeeping in an exhibit room, and any other duty given to me by my superior. I know the defendant on the 18th day of May 2023.
Yes.
I, myself, Mohammed Rabi Suleiman, CNA, and Davis Bambis, CSN.
Yes.
Arrested Suleiman Bulama.
Go ahead.
Alon Ngamdu Damaturu Way. With a black polythene bag. Inside the black polythene bag is dried leaves suspected to be cannabis sativa. We immediately brought him to our office. In the office, Suleiman Bulama admitted that the black polythene bag belongs to him.
Yes.
And I informed him that I want to carry out a field test on these dried leaves. And he said yes, and which I did. And the test proves positive for cannabis sativa weighing 900 grams.
Yes.
Then I bring out some exhibit forms, namely certificate of test analysis, packing of substance form, request for scientific aids.
Yes.
I fill the necessary column. The arresting officer also fill his own column, and the defendant thumbprint on the columns. And I kept the bulk of the exhibit in an exhibit room.
Yes.
And the forensic is not yet ready, my lord. Thank you.
Thank you very much. In the course of your testimony before this honorable court,
Yes, my lord.
do you remember taking the statement of the defendant?
Yes, my lord.
Thank you very much. If you see the statement, would you be able to identify it?
Yes, my lord.
Thank you very much. In your examination in chief, you further stated that you filled the exhibit forms.
Yes, my lord.
In which the defendant also thumbprinted on it.
Yes, my lord.
Which included certificate of test analysis, packing of the substance form, and request for scientific aid.
Yes, my lord.
You further stated that you checked the bulk of exhibit for safekeeping in your custody.
Yes, my lord.
Now, tell this honorable court how you'll be able to identify the said statements you took, the defendant statement, the packing of the substance form, the certificate of test analysis, request for scientific aid, and the said bulk of exhibits before this honorable court.
In all of the documents, my lord, my name was written there, my signature, and the date of documentation, my lord.
What of the bulk of exhibit?
My name is also written there, and the date of documentation.
My lord, we apply for the witness to identify the said documents, my lord.
Yes. Go ahead.
Are they the documents you're talking about?
Yes, my lord. They are done, my lord.
My lord, we equally apply for the witness to bring forth the said bulk of exhibit, my lord, for identification.
Yes, application granted.
Shi wannan riga ba da shaida ya ce yana daga cikin waɗanda suka kama ka. Bayan sun kama ka, ya ce akwai takardu da suka ciccike, gurbi suka sa hannu kai ma ka dangwala, da kuma kayan da aka kama a wajen ka ake zargi ta baruwi ce. Saboda haka yanzu shi mai gabatar da ƙara ya zo ya nemi kotu cewa kotu ta duba wannan abu ta gani a tabbatar cewa su ne wanda aka kama. An ba shi damar yin haka.
My lord, we apply for the witness to open the said black polythene bag to ascertain what it contains.
Yes, go ahead. Application.
Nemi kotu ta ba shi izini kuma a buɗe wannan da ya yake.
My lord, this is the bulk of the exhibit.
Wannan shi ne abu da aka kama ka da shi.
Yes, the bulk of the exhibits. Can you raise it up again? Because the camera is not on. Yes. How is it concealed? Inside what?
It's a white sellotape and some red knots on it.
Okay.
Yes, my lord.
My lord.
Okay. Bulk of the exhibit. Is that compressed weed?
Yes, my lord.
And I want a proper definition. Is it in a paper that has been sellotaped?
No, my lord. It's a white sellotape, but under the sellotape, there are some written notes with red ink, with red color in the sellotape.
Okay.
Yes, my lord. Dread note are inside the sellotape, my lord.
Yes, okay.
Yes, my lord.
Tana nuna ma kotu wannan abu da aka kama a wajenka. Kotu tana tambaya da wani irin kamanni yake da yaya yake shine bayanin da yake wa kotu.
Okay. And how much does it weigh?
900 grams, my lord.
Okay.
Nauyinsa ya kai kamar nawa sai aka ce gram 900.
Yes.
My lord, in the circumstances, my lord, we sought to tender the packet of the substance form, the certificate of the test analysis, the request for scientific aid, the statement of the defendant, my lord, and the bulk of exhibits in evidence before this honorable court.
The bulk of the exhibits, what is the number written there?
NDLEA stroke YBSC.
Go ahead.
Stroke 011 stroke 2023.
Okay, thank you.
Thank you, my lord.
The following exhibits are hereby admitted into evidence. The exhibit forms comprising of certificate of test analysis form, packing of substance form, request for scientific aid form, hereby marked as NDLES Layman 1A, 1B, and 1C respectively. The bulk of the exhibit of compressed blocks wrapped in transparent sellotape weighing 900 grams, marked as exhibit NDLEA Ibrahim 2.
As please. But that's all for the examination in chief.
questions to ask the witness.
As the court pleases, wayannan abubuwa da aka gabatar a matsayin shaida a kanka, yanzu kotu ta karba sun zama shaida a kanka har da wannan busasshen ganye wanda ake zargin taba gwiwi ce. So kana da wani tambaya da za ka yi wanda ya bada shaida a kanka? Ka kalli, ka bude murya. Ba ka da tambaya? He has no question to the witness, my lord.
Show the defendant the exhibits and ask him whether those are the exhibits recovered from his possession when he was arrested.
As the court pleases, ka duba ka gani waɗannan takardu wanda ka dangwala hannu wayannan suka sa hannu mai bada shaida su ne waɗanda aka kama ka lokacin da aka kama ka wajen da wannan jawabi shi ma naka ne? Wannan shi aka kama ka da shi wannan wiwi. He admitted them, my lords.
My lord, that's all for the review of facts through the executive officer. We apply for the executive officer to be discharged from the witness box.
Application granted. Thank you, officer.
Thank you, my lord.
Ya gama ba da shaida a kanka yanzu.
My lord, you could apply for the court to convict the defendant as charged.
Ask the defendant whether the facts are stated by the prosecution and the exhibits as presented by the exhibit keeper, as well as the statements as presented by the NDLA officer, reflect the true position of the case.
As the court pleases, wannan takardu da na baka wanda kotu ta karba a matsayin shaida a kanka da wannan wiwi da aka gabatar a gaban kotu wanda shi ma da shi aka kama ka da shaida da mai bada shaida a kanka ya bayar, dukkan sun tabbatar da gaskiyan shari'a naka da ake a wannan kotu? Ka faɗi magana a jika. Sun tabbatar. He admitted it, my lord.
In view of the plea of the defendant and in accordance with section 356(1) and 2 and 2741B of the Administration of Criminal Justice Act 2015, and in addition to the exhibits before the court, ask the defendant whether he has any cause to show why he should not be convicted as charged.
As the court pleases, kasancewa ka aikata wannan laifi ka amsa laifinka, kana da hujja da zaka gaya wa kotu da zai hana amma hukunci? Kai magana. He has no cause to show, my lord.
The defendant, who on arraignment pleaded guilty to the charge, has not produced any evidence of lawful possession of exhibit Suleiman 1 and 2. I'm satisfied against his plea of guilty and the field-tested proofs of exhibits 1A, B, and C, that the case against the defendant has been proved beyond reasonable doubt as is required by sections 137 and 138 of the Evidence Act. Excuse me. The defendant, Suleiman Bulama, is hereby found guilty and convicted as charged. I shall listen to the allocators of the convict before I pronounce on his sentence. This shall be the judgment of this court on the basis of the charge brought before the court.
As the court pleases, bayan kotu duka ta gamsu da hujjoji da aka gabatar mata, kotu ta gamsu cewa kai yanzu mai laifi ne, saboda haka yanzu kotu ta kama ka da laifi. Kana da wani abu da zaka faɗa ma kotu?
Any record of previous conviction?
My lord, the convict has no previous record of conviction. My lord, he has admitted the commission of the crime from the first step of investigation, my lord. My lord, I urge this honorable court to consider it as part of the investigation part. Thank you very much.
Canada.
Does he have anything to say to the court?
Ko wani abu da zaka faɗa ma kotu? Ka kalli kotu. Ka bude mu bakin ka kai magana.
Haka.
Me zaka gaya wa kotu?
Ina mai doya kuriya a kotu. Ai kuskure na laifi.
Kai daga murya a jika.
ina kuskure a kotu saboda na ɗauko kayan laifi kotu da mun ɗauki kayan laifi.
What was he doing with this illicit substances? Is he selling or is he smoking? What is it?
Me kake yi da wannan tabar wiwi da aka kama ka? Kana sayarwa ne ko kana sha?
Ina sayarwa ne.
Ka daga murya ka kalli kotu.
Ina sayarwa ne.
He sells it, my lord.
What does he do for a living?
Me sana'ar ka?
Ni makaniki ne.
This matter was called. The defendant is in court, and consequently, the review of facts done. The convict will be sentenced shortly.
As the court pleases.
Sentence.
As the court pleases.
On the 10th day of July 2023, the defendant, Suleiman Bula Maherin, was adjudged guilty of the indictment in the charge sheet dated 8th May and filed 10th May 2023 based on a plea of guilty, which he entered when he was arraigned before this court on the 10th day of July 2023. In the final analysis, the convict is hereby sentenced to 9 months imprisonment. The sentence shall be deemed to have commenced from the 8th day of May when he was arrested by a team of NDLA officers at 9-hour area, Damaturu State, within the jurisdiction of this court. The seized drugs being cannabis sativa admitted as NDLEA Suleiman, which weighed 900 grams, is hereby confiscated and shall be forfeited to the federal government of Nigeria. The said exhibit shall be destroyed by burning by the NDLEA, which, along with other judicially condemned narcotics and psychotropic substances at a public function to be organized by the NDLEA, which shall be witnessed by the Nigerian Police Force, Department of State Security Service, Nigerian Security and Civil Defense Corps, as well as the print and electronic media and the general public. This shall be the court sentence of the convict, which I deferred till today. The sentence is no doubt very light. It was deliberately done or made so in order to encourage the convict to retrace his steps and return to the society as a reformed person. The convict may not be so lucky if in the future he is caught and charged for a similar offense.
As the court pleases, a takaice, kotu bayan samun ka da laifin nan da ta yi, ta ɗaure ka wata tara. Wata tara nan kuma irgen zai fara daga 8 ga watan 5 na shekarar nan da muke ciki, wato ranar da ma'aikatan NDLEA suka kama ka. Daɗin daɗawa kotu ta ce wannan hukunci da ta yi maka ba shi da tsauri. An yi maka ne saboda ka gyara halinka ka dawo mutumin kirki, ka rungumi abin da zai taimake ka a rayuwa. Amma a karo na biyu in aka sake kama ka da aikata makamancin irin wannan laifi, to hukuncin da doka ta tanadar kaɗan daga ciki shine ɗauri shekara 15, mai yawa kuma shine shekara 25. Saboda haka ka kiyaye. A takaice kenan.
Thank you. Please call the next case.
Next case is Amir Mohammed Musa.
Charge number FSC/DM/CR/20/2023 between the Federal Republic of Nigeria and Amir Mohammed Musa.
Prince.
Yes, my lord. The defendant is here present at the operational center, Portisco, my lord.
Yes.
Respectfully, my lord, my name is Usman Bamana. My humble appearance is for the complainant. My lord, the matter is fixed today for review of facts. Subject to the convenience of my lord, we are ready to proceed, my lord.
Yes. Go ahead.
My lord, I want to review the facts of this case through the 2IC exhibit, Mr. Mohammed Rabiu Suleiman, my lord.
Yes.
Yes, my lord. PW1 is here at the correctional center, and he is already on oath, my lord, at the previous cases.
Yes.
Once again, tell this honorable court your name again. What do you do for a living? What is your rank? What are your schedules of duties? And what do you know about this case? Very good.
My name is Mohammed Rabi Suleiman. I work with the National Drug Law Enforcement Agency, Yobe State Command. I'm a chief narcotic agent. My schedule of duties are receiving of suspect and the exhibit recovered from them, carrying out a field test on the exhibit recovered from the suspect, issuing of exhibit forms for the defendant to bring, witnessing and arresting officer also to sign, giving an entry of the bulk of the exhibit in an exhibit room for safekeeping, taking A1 to Lagos for scientific analysis, testifying and giving evidence in court with regard to the exhibit kept by me or handled by me, and any other advocate given to me by my superior. I know the defendant. In respect of this case, the defendant was brought before me on the 15th day of March 2023. 15th day of May, my lord. 15th day of May 2023.
Yes.
By Abubakar Umar Sanda, SN2, and Musa Abdullahi, CNA.
Wannan shine mai bada shaida a kanka game da shari'ar nan da ake yi. Yanzu a takaice ya faɗa ma kotu ayyukansa ne a wajen aikinsa.
Along with a black MP3 radio.
Yes.
Inside the black MP3 radio is white substance concealed inside. White substance similar to Ajinomoto concealed inside the MP3.
Yes.
I asked the defendant who owns this MP3 player, and he responded that it belongs to him. Then I bring out this white substance that looks like Ajinomoto from the MP3 and tell the defendant
Yes.
that I want to carry out a field test on this substance, and he said yes. When I carry out the field test, the test proved positive for methamphetamine.
Yes, go ahead.
And it was also weighed, and it weighed 112 grams.
112 grams.
Yes, my lord.
Yes.
So,
yes.
Thereafter, I bring out some exhibit forms, namely certificate of test analysis, packaging of substance form, request for scientific aid forms. I fill out the necessary columns. Witnessing and arresting officer also fill their columns, and the defendant don't print on the columns. I took some parts of the methamphetamine and sealed it inside a white evidence transparent pouch, which will be taken to Lagos for scientific analysis.
Wanda shi mai bada shaida yake faɗa, wannan sun kama ka da MP nan da suka kama ka da shi suka ce za suna so su bude cikin su yi bincike, suka bude sai suka samu wani farin abu nan da ake ce methamphetamine, suka bude sai suka ce za su yi kwarya-kwaryan gwaji a kai, suka yi kwarya-kwaryan gwaji kuma sun tura ma ainihin ofishin su na Lagos, za su tura ma ofishin su na Lagos a sake yin gwaji na kwararru a kai. A kuma wasu takardu da ya ce ka ciccika kai ma ka sa hannu, shi ma ya sa hannu, da ma kuma waɗanda suka kama ka duka sun sa hannu a kai. Abin da yake faɗa ma kotu ke.
And I kept the bulk of the exhibit in an exhibit room for safekeeping. That's all, my lord.
Yes.
Mr. Mahmoud Rabi Suleiman.
Yes, my lord.
You made mention that you took some exhibit forms.
Yes, my lord.
And you also kept the bulk of exhibit for in your custody,
yes,
for safekeeping.
Yes, my lord.
Please, can you identify the said bulk of exhibits here with the exhibit forms?
Yes, my lord.
How would you identify?
In all the documents, my name is written there, my signature, date of documentation, and in the bulk of the exhibit, the NDLA case file number was also written there.
My lord, we apply to show the witness the said exhibit forms for identification.
Yes. Go ahead.
Ya gaya ma kotu cewa kotu ta tambaye shi akan iya ga wannan takardun zai gane wanda ya ciccika, kai ma ka sa hannu ya ce zai gane. Abin da ya sa zai gane akwai sunansa a rubuce da sa hannunsa, da wayanda suka kama ka akwai sa hannunsu, kai ma kuma ka dangwala a kai. Shi kuma wannan MP da aka kama a wurinka,
We equally apply for the witness to bring forward the bulk of exhibit for identification.
Yes, go ahead.
An buƙaci a kawo wannan MP shine aka ɗauko yanzu.
Why don't we apply for the witness to open the said white transparent letter which contains the exhibit ballot to ascertain what it contains.
Yes, go ahead.
Kotu ta ba da izinin a buɗe a ga me yake ciki, kamar yadda mai gabatar da kara ya nemi kotu ta ba shi izini.
My Lord, this is the bulk of the exhibit, and this is the MP3 they use as a mode of concealment. We put the black MP3 inside white leather for easy of conveying it to the court. And this is the sample of the methamphetamine that are concealed inside the MP3, my Lord.
Na faɗa ma kotu ya ce shi ne wannan methamphetamine da aka samu a cikin wannan MP3. Dalilin sa wannan leda kuma saboda su samu sauƙin kaiwa kotu, kar wani ruwa ko wani abu ya taɓa.
Yes. Any number written?
Yes, my Lord. NDLA/YBSC/016/2023.
Na faɗa ma kotu wannan lambobi da yake rubuce a cikin.
Yes.
My Lord, we apply to tender the state party of the substance form, certificate of test analysis, a request for scientific aid form, together, my Lord, with the board of exhibit and the concealment, my Lord, in evidence before this honorable court.
Following exhibits are hereby admitted into evidence. The exhibit forms comprising of certificate of test analysis form, packing of substance form, request for scientific aid form hereby marked as NDLEA Amir 1A, 1B, and 1C respectively. The black colored MP3 player concealing the bulk of the exhibit of methamphetamine powder is marked as NDLEA Amir 2.
As copied.
Methamphetamine.
Madam,
Yes.
we equally apply to tender the statement of the defendant, both the English and Hausa version across the bar.
The statement of the defendant in English and in Hausa language and the English version is hereby admitted into evidence as NDLEA Amir 3A and 3B respectively.
As copied. Well, that's all for the examination, Chief.
Yes. Prosecuting counsel.
My lord.
Okay. Oh, I see. Do you have any, the defendant, ask the defendant whether he has any question to ask the NDLEA officer, the witness.
As the court pleases. My lord, I'm sorry, before that, my lord, the content of the exhibit has not been counted.
I thought, is it not powder? Is it tablets?
No, my lord. They are in pieces. They put it inside
A leather.
inside a leather and they wrap it in pieces.
And is it tablets or powder?
No, it's in solid form, my lord.
Solid form?
Yes, my
Okay,
lord.
how many pieces there?
I think it's about that something, my lord.
You ought to, because you are holding it, you ought to tell me. You said you think. Mustafa is going to be in the custody of the court. You should find out how many.
Yes, we can quickly count it, my lord. Let's count it.
Quickly, we are waiting for you.
3, 4, 5, 6, 7, 8, 21, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34.
My lord, there are 35 pieces, but we took one for forensic. Here is 34 pieces, my lord.
Okay. The methamphetamine exhibits amounting to 34 pieces inside transparent polythene, concealed inside a black colored MP3 player, containing the bulk of the exhibit is marked as NDLEA Amir 2.
Well, that's all for the examination, Chief.
Okay. Ask the defendant if he has any questions to ask the witness.
As the court pleases. Amir, kana da tambayar da za ka yi wani mai ba da shaida a kan kaza? He has no question to the witness, my lord.
Let him speak up.
Kai magana a jika.
Ban da wani tambaya da zan masa.
Show the defendants the exhibits and ask him whether those are the recovered exhibits found in his possession when he was arrested.
As the court pleases. Waɗannan takardu da aka ciccike da kuma wannan ainihin abu da aka kirga a cikin MP wannan duka su ne wanda aka samu a wajenka ya tabbata? Ka daga murya a jiki.
Hakika ya tabbata.
Ya limited my lord.
Yes, prosecuting counsel.
My lord, that's all for the review of facts through the exhibit officer. We equally apply for the exhibit officer to be discharged from the witness box.
Okay, application granted. Thank you, officer.
Thank you, my lord.
My lord, we apply for the defendant to be convicted as charged.
Ask the defendant whether the facts are stated by the prosecution and the exhibits as presented by the exhibit keeper, as well as the statements presented by the NDLEA, reflect the true position of the case.
As the court pleases. Amir, wannan hujjoji da aka gabatar a kanka da kalli kotu. Hujjoji da aka gabatar a kanka wanda ya kunshi wayannan takardu da aka ciccika kai ma ka dangwala hannu da wannan mai tafin da aka kama a wajenka duka ya tabbatar da gaskiyan wannan shari'a da ake yi yanzu. Ya tabbata.
Whether the defendant has any cause to show why he should not be convicted as charged.
Kana da wani hujja da zaka gabatar ma kotu wanda kotu ba za ta hukunta ka ba? He has no cause, my lord.
The defendant who indicated that he was not literate in English language had the charge dated 26 June 2023 on file 4th July 2023, read and interpreted to him through a sworn interpreter. He pleaded guilty to the charge. The learned prosecutor consequently indicated his intention to conduct a review of the facts of the charge. This has been done. I've listened to the learned prosecutor, Usman Bamala Esquire, who has produced certain documentary and real exhibits, which have been admitted in evidence. Exhibits Amir being the bulk of the exhibits seized and recovered from the defendant on 17th day of May 2023 in the course of follow-up operations by NDLA officers. It's one of the drugs which the extant legislations has outrightly, except where lawful authority is shown, prohibited sale, possession, and consumption. The defendant, who on arraignment pleaded guilty to the charge, has not produced any evidence of lawful possession of the exhibit. I'm satisfied against his plea of guilty. And the field-tested proofs of exhibits that the case against the defendant has been proved beyond reasonable doubt as is required by sections 137 and 138 of the Evidence Act. In view of the plea of guilt entered by the defendant and in line with the provisions of sections 2741 and 2 and 3561 and 2 of the Administration of Criminal Justice Act 2015, this court hereby finds the defendant Amir Muhammad Musa guilty of knowingly without lawful authority found and arrested dealing in 112 grams of methamphetamine and amphetamine substance, a psychotropic substance similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under Section 11 of the NDLEA Act, Cap 30, Laws of the Federation of Nigeria, 2004. The defendant, Amir Muhammad Musa, is hereby found guilty and convicted as charged. I shall listen to the allocators of the convict before I pronounce on his sentence. This shall be the judgment of this court on the basis of the charge dated 5th June and filed on the 19th June 2023. Any record of previous conviction?
My Lord, the convict has no previous record of conviction. My Lord, the convict has admitted the commission of the crime right from investigation. He has been a friend in the course of interrogation. And my Lord, he did not stretch this honorable court to undergo a rigorous trial. I urge this honorable court to consider the stated facts as part of mitigating factor. My Lord, as for aggravating factor, the purported exhibit found in possession of the convict, my Lord, is not an ordinary exhibit that is usually found or produced in the country. I urge my Lord to consider it as part of the aggravating factor. Thank you very much, my Lord.
Abinda shi mai gabatar da kara ya faɗa ma kotu ya ce na farko dai tukunna a wajen yin bincike kotu ta tambaye shi kana da wani makamancin laifi haka da ka taba aikatawa aka kama ka, ya ce babu irin wannan makamancin laifin. Abu na biyu ya ce kai dinnan ka kasance kamar aboki yayin da ake yin bincike baka ba su wahala ba wajen yin bincike. Daɗin daɗawa kuma baka ɓata ma kotu lokaci an ta yin shari'a kan wannan kama ka da laifi da aka yi ba. Har yanzu kuma ya tabbatar ma kotu cewa wannan kayan barasa da aka kama a wajenka ba kayan barasa ne wanda aka fi sani yau da kullum ake samun sa ko ina ba. Hasali ma ana shigowa da shi daga ƙasashen waje ne. Abin da ya gaya ma kotu.
Does he have anything to say to the court?
Akwai wani abu da zaka faɗa ma kotu? Ka kalli kotu.
Ba da wani abu da zan.
Ka ɗaga murya a jika.
Babu wani abu da zan iya cewa.
He has nothing to say, man.
This is Ali Kitches. So he said he doesn't have anything to say to the court.
Wannan magana yanayi ne wanda ake ciki wanda zaka iya neman alfarma a wajen kotu. Ba wani alfarma da zaka nema a wajen kotu?
Akwai alfarma da zan roƙa wurin kotu.
To ka roƙi alfarma a wajen kotu.
Ina roƙon wannan kotu mai adalci mai alfarma ta duba yanayin da muke ciki. Kasancewa ni maraya ne ba uwa ba uba kuma ga matana da yara biyu yanzu haka ma na ɗauki da juna ko yau ko gobe. Ina roƙon
Ana rubuta.
Yes.
Ci gaba.
ko yau ko gobe ga kuma ƙannena guda 5 wanda duk ni nake ɗaukan nauyinsu.
Yes.
Da ta duba da tausaya kasancewar wannan aikin ba mai kyau ba ne amma kuma har aka yi bincike aka kama ni da shi. Ina roƙon alfarma a gurin kotu mai daraja mai ɗaukaka da ta sassauta mana hukunci.
Kotu ta ce.
Is that it?
Shikenan.
Shi ne dai alfarman da zan roƙa a gurin kotu.
Where did you get such exhibit?
Wannan kayan barasan ina ka same shi?
Har ga Allah ba na bane. Sako aka bayar a kawo.
Ci gaba.
Ba ma ni na taho da shi ba. wanda ya taho da shi aka bari ya kawo mun akan ya ba wani to bai san wancan din ba sai ya kawo mun sai ce wani da Allah ga wannan abin ba wani to shi wancan din da ya ji labarin an kama ni an kama wancan din ma kawai sai ya gudu yana jin an kama wancan wanda ya taho da kayan sai ya gudu shi kuma da ya zo
dakata haka
Yes.
sai muka neme shi muka rasa to ni kuma ba na so mu zo mu samu wannan inda sakamakon mu masu karamin karfi ne ba wani karfi da muke da shi wanda za mu iya ja da gwamnati nake roƙon kotu mai alfarma da ta mana adalci.
What was his last statement?
Me ka faɗa na ƙarshe?
Ina roƙon kotu mai alfarma da ta mana adalci.
He said, he can't fight with the government.
Ka ce ba za ka iya ja da gwamnati ba ko?
Saboda mu masu karamin karfi ne.
Kai mai karamin karfi ne.
Madam Mustafa, interpreter, ask the convict who owns the exhibit.
As the court pleases, asalin kayan nan nawaye ne?
Asalin kayan na wani ne a Lagos da ya ji an kama wanda ya taho da kayan sai ya gudu.
Sentencing. This matter was called, the defendant, the convict is in court, and consequently the review of facts done. This honorable court shall sentence the convict shortly.
As completed.
Malam Mustafa.
My lord.
Please ask the defendants, where do they get it and what do they do with it?
Ina kuke samun wannan kayan barasa kuma me kuke da shi? Ka kalli kotu.
Wannan kaya ban san a ina suka samu har ga Allah saboda kuma ban san ya ake da shi. Kawai ya aiko ne a ba wani.
Thank you, Malam Mustafa.
Thank you, my lord.
Can you mute your microphone? Sentence. Potiskum Correctional Center, can you hear me? Okay, it's okay.
We can hear you, my lord.
Okay, it's okay.
Yes.
Sentence.
As the court pleases.
On the 10th day of July 2023, the defendant Amir Muhammad Musa hearing was adjudged guilty of the indictment in the charge sheet dated 5th June 2023 and filed on the 19th day of June 2023 based on a plea of guilty, which he entered when he was arraigned before this court on 10th day of July 2023. The sentencing was deferred to today to enable me to have a deeper reflection of the appropriate sentence, which will meet the justice of his case. In criminal jurisprudence, the two broad goals of judicial sentencing are firstly to seek the reform of the convict so that by the time he completes the penal custodial sentence which the court imposes, he will return to the society as a better and more responsible citizen who has respect for the laws of the land. The second goal is to impose such sentence as will serve as deterrence to the other persons who are yet to be caught by the proverbial long arm of the law, who are also involved in similar acts for which the convict is being punished. Whilst the first goal focuses on the convict in the dock, the second goal, in my view, focuses on both the convict in the dock and the society at large, especially for persons who are or may be involved in similar criminal activity for which the convict is being sentenced. In relation to the convict, the sentence the court will impose it to be such as will deter him from going back into the same or similar activity as constituting the offense for which he's been punished, whilst for the other persons out there who are yet to be caught in the web of the law, to persuade them to desist on pain of similar punishment from continuing with or not to go into similar activity. The court is also required, especially in cases involving illicit trafficking in narcotics, to take into consideration the nature of the drugs involved. In this case, the defendant was convicted of being in unlawful possession of methamphetamine. The provisions of the NDLEA Act stipulates different regimes of punishment for unlawful possession of such psychotropic substances. The court in such case will consider the quantity found in possession of the convict when arrested, or the defendant while arrested. This enables the court to ascertain whether the defendant is a mere user or abuser of hard drugs or is someone who is either a retail or commercial dealer. By considering the quantity of the hard drugs, it enables the court to assess the extent of harm which the defendant has done to himself as a consumer or to the society as a retail or commercial dealer of illicit hard drugs. In the final analysis, the convict is hereby sentenced to 20 months imprisonment with hard labor. Imprisonment, remove the hard labor.
With hard labor, my lord?
No, just 20 months imprisonment. The sentence shall be deemed to have commenced from the 15th day of May 2023 when he was arrested by a team of NDLEA officers dealing in 112 grams of methamphetamine and amphetamine substance recovered along Hadejanguru Road within the jurisdiction of this court. The seized drugs admitted as exhibits, which weigh 112 grams, is hereby confiscated and shall be forfeited to the federal government of Nigeria, and shall, as judicially condemned narcotics and psychotropic substances at a public function to be organized by the NDLEA to be burned. This shall be the court sentence of the convict, which I defer till today in order to reflect on the appropriate sentence. The sentence is no doubt very light. Haven't heard from the convict. It was deliberately made so in order to encourage the convict to quickly retrace his steps and return to his family, particularly his children. The convict may not be so lucky if in the future he is caught and charged for a similar offense. This shall be the court sentence.
As the court pleases, Ali kotu a takaice wannan laifi da kai kotu da ta kama aka kawo ka kotu ta yanke ma hukunci daurin wata 20. Wata 20 zai fara daga ranar da aka kama ka, wato 15 ga watan 5 na shekarar nan da muke ciki. A tsari na shari'a kuma kotuna suna hukunta mutum ne mai laifi saboda wasu dalilai biyu. Dalili na farko, saboda shi wanda ya aikata wannan laifi in ya zo ya zauna a gidan yari ya canza ɗabi'unsa bayan ya gama zaman gidan yari ya zama mutumin kirki ya taimaki kansa a rayuwa. Dalili na biyu kuma shine waɗanda suke aikata makamantan irin wannan laifi da ya aikata ya zame musu izina, wanda doka bata samu ta kama su ba su daina irin wannan. Saboda haka kai kotu ta yi maka sassauci, ta ɗaure ka wata 20. Sannan kotu tana sake umartanka idan kai rashin sa'a ka sake aikata irin wannan laifi karo na biyu aka kama ka, to kotu fa za ta rufe idanta, za ta yi maka hukunci yadda doka ba sassauci. Ɗauri kaɗan daga ciki abin da doka ta tanadar shekara 15, mai yawa 25. Saboda haka ka kiyaye. Ya ka zo.
Thank you, Madam Mustafa. Please call the next case.
Thank you, Madam. Call the next case.
Charge number FKC/DM/CR/22 2023 between the Federal Republic of Nigeria and Umar Mohammed.
Sorry, Umar Mohammed. Umar Mohammed. Umar Mohammed. Yes, my lord. The defendant is here at the Correctional Defense Center, Potiskum, my lord.
Respectfully, my lord, my name is Usman Bawada. My humble appearance is for the complainant. My lord, the matter is fixed today for review of fact, and subject to the convenience of my lord, we are ready to proceed. My lord, I intend to review the fact of this case through the exhibit officer, my lord.
Let's go ahead.
Thank you very much, my lord.
Yes, my lord. PW1 is here present at the Correctional Center, and he is already on oath at the previous cases, my lord.
Yes.
Please, once again, tell this honorable court your name, what is your rank, what are your schedules of duties, and what do you know about the defendant in this case? Very briefly, considering the fact that the defendant has pleaded guilty.
My name is Mohammed Rabi Suleiman. I work with the National Drug Law Enforcement Agency, Yobe State Command. My schedule of duties are receiving of suspects and the exhibit recovered from them, carrying out a field test on the recovered exhibit, weighing of the exhibit, giving an entry of the bulk of the exhibit to an exhibit room for safekeeping, any other duty given to me by my superior. The defendant was brought before me on 9th of May 2023.
Yes.
By Mohammed Abdul Malik and Abdullahi Abubakar Ahmed. Along with a black polyethylene bag. I asked the defendant who owns this bag, and he replied that it belongs to him. When I opened the polyethylene bag, I discovered that there are dried leaves suspected to be cannabis sativa, and I informed the defendant that I want to carry out a field test, and he assented it. And the test proved positive for cannabis sativa, and it was weighed 800 grams.
Yes.
I bring out some exhibit forms, namely certificate of test analysis, packaging of substance form, request for scientific aid forms. I fill the necessary columns. Witnessing and arresting officer also fill their own columns, and the defendant printed on the forms.
Yes.
I took some part of the exhibit and sealed it inside a white evidence transparent pouch, which will be taken to labs for forensic analysis. And the bulk of the exhibit was kept in an exhibit room for safekeeping. That's all, my lord.
Mr. Muhammad Gabi Suleiman.
Yes, my lord.
You made mention before this honorable court that you filled some exhibit forms to the defendant, in which you also thumbprinted.
Yes, my lord.
And you further stated that you kept the bulk of exhibit in your custody for safekeeping.
Yes, my lord.
Please, can you tell this honorable court how you'll be able to identify the said exhibit forms together with the bulk of exhibits?
In all the documents, my name is written there, my signature, date of documentation, and on the bulk of the exhibit, the NDA case file number was also written there.
Wannan shi ne yake ba da shaida a kan ka kalli kotu kuma ya ce lokacin da aka kama ka an kawo ka akwai wasu takardu da ya ciccika wanda ya sa hannu kai ma ka dangwala da ma wayanda suka kawo ka duka wajen su sa hannu duka shi ne yake gaya ma kotu kuma a takaice ya gaya ma kotu yanayin aikinsa da yake a ofis. Ka fahimta? Ana kallon kotu.
My lord, we apply for the witness to identify the said exhibit forms, my lord.
Yes. Go ahead.
Yanzu ya buƙaci kotu a duba wannan
My lord, they are
takardun
done.
a tabbatar cewa
You
kotu
only
ne.
apply for the witness to bring forward the said bulk of exhibit for identification, my lord.
Yes, go ahead.
My lord, we apply for the witness to open the said black polythene bag to ascertain what it contains.
Application granted.
Copy.
Ta buƙaci kotu da ta ba da izini a buɗe wannan leda a game take ciki kotu kuma ta ba da izinin haka.
My lord, these are the bulk of the exhibit, but they are affected by rodents.
Is it just one package, and you have brought out something out of it?
This one is all one compressed block.
Yes,
But it's
okay.
affected by rodents, and there are some Thai ones inside a white leather.
Okay. Those that were tied, how many? Or is that only one?
No, my lord.
There are 9, my lord.
Okay. Yes, what is the number written on it?
NDLA stroke YBSC stroke 013 stroke 2023.
Yes.
That's all, my lord.
My lord, in the circumstances we sought to tender the packing of the substance form, certificate of the test analysis, request for scientific aid form, together with the bulk of exhibit in evidence before this honorable court.
Shi mai gabatar da ƙara yana buƙatar kotu ta ba shi dama ya ba da wayannan kayayyaki da kaya da aka kama wurinka da waɗannan takardu da aka cike su zama shaida a kanka wannan shari'a da ake. Ka fahimta?
The following exhibits are hereby admitted into evidence. The exhibit forms comprising of the certificate of test analysis form, packing of substance form, request for scientific aid form, hereby marked as NDLEA Amir 1A, 1B, 1C. The bulk of the exhibit of compressed blocks and some 9 pieces tied in wraps concealed inside a black polythene bag marked as exhibit NDLEA Amir 2.
My lord, this Umar Mohammed.
Okay, sorry, I'm Umar.
Ascop, please. Ascop, please.
It's Amir and Umar kind of. Umar, yes, NDLA Umar 1A, 1B, 1C, and NDLA Umar 2.
Ascop, please. My lord, we equally apply to tender the voluntary statement of the defendant, my lord, both Hausa and English version, in evidence before this honorable court. We sought to tender them across the back.
The extrajudicial statement of the convict in Hausa language and translated version in English language is hereby admitted into evidence as NDLEA Umar 3A and 3B respectively.
As the court pleases.
My lord, that's all for examination in chief.
Ask the defendant if he has, the convict, if he has any questions to ask the witness.
As the court pleases. Umar, kana da wani tambaya da zaka yi wanda ya bada shaida a kanka? Daga murya kwaya jika kalli ko. He has no question to the witness, my lord.
My lord, that's all for the review of facts through the exhibit officer. I equally apply for the exhibit officer to be discharged from the witness box.
Show the defendant the exhibits and ask him whether those recovered exhibits were the ones found in his possession when he was arrested.
As the
As
court
well as
pleases.
the statements, whether it was the one he thumbprinted.
As the court pleases. Wannan wiwi da aka kama, ko? Da kuma wannan takardu, da ma wannan jawabi da aka rubuta shi ta Hausa, aka sake rubuta shi ta Turanci. Dukkan su ne wanda aka yi kasa hannu a ciki? Su ne? Wannan wiwi din ma shi ne aka kama ka da shi? Yes, my lord, he admitted it.
NDLEA officer, the witness is discharged. Thank you so much.
Thank you, Lord.
Ask the defendant whether the facts as stated by the prosecution and the exhibits as presented by the exhibit keeper reflect, as well as the statements as presented, reflect the true position of the case.
As the court pleases, Umar, wannan shaida da wannan ya bayar, wanda mai gabatar da kara ya kira, da wannan wiwi, da wannan ainihin jawabin ka da aka rubuta ka sa hannu, suka sa hannu duka, da ma hujjoji da mai gabatar da ya kara ya gabatar wa wannan kotu. Ya tabbatar da gaskiyan wannan zargi da ake maka na wannan shari'a da ake yi. Gaskiya ne. Ya admitted, my lord.
Thank you.
In the circumstances, my lord, we urge this honorable court to convict the defendant as charged.
Whether the convict has any cause to show why the defendant has any cause to show why he should not be convicted as charged?
As the court pleases, kana da wani hujja da
I didn't hear him.
ka faɗa kotu ta ji. Kana da hujja da zai hana kotu ta hukunta ka? Babu.
The defendant who indicated that he was not literate in English language had the charge dated 26 June 2023 and filed 4th July 2023, read and interpreted to him through a sworn interpreter. He pleaded guilty to the count in the charge. The learned prosecutor consequently indicated his intention to conduct a review of the facts of the charge. The defendant has not produced any evidence of lawful possession of exhibits Omar, and I'm satisfied against his plea of guilty and field-tested proof of exhibits that the case against the defendant has been proved beyond reasonable doubt that is required by sections 137 and 138 of the Evidence Act 2011. In view of the plea of guilty entered by the defendant and in line with the provisions of sections 2741 and 2 and 3561 and 2 of the Administration of Criminal Justice Act 2015, this court hereby finds the defendant Umar Mohammed guilty of knowingly without authority, found and arrested in possession of 800 grams of cannabis sativa, and thereby committed an offense contrary to and punishable under Section 19 of the NDLEA Act, Cap. 30 laws of the Federation of Nigeria. The defendant, Umar Mohammed, is hereby found guilty and convicted as charged. I shall listen to the allocators of the convicts before I pronounce on his sentence. This shall be the judgment of this court on the basis of the charge dated 26 June 2023 and filed 4th July 2023.
The court pleases. Yanzu kotu ta same ka da laifi, kai yanzu ka zama mai laifi ne. Umar, ka fahimta?
Any record of previous conviction?
My lord, the convict has no previous record of conviction, my lord. My lord, the convict did not stress the investigation of this case, my lord. He also did not stress this honorable court to undergo a rigorous trial. Thank you very much.
Shi mai gabatar da ƙara an tambaye shi, kotu ta tambaye shi akan ka taba aikata laifi irin wannan da aka kama ka, ya ce a'a babu, ba ka taba kama ka da irin wannan laifi ba. Daɗin daɗawa baka ba su wahala wajen yin bincike ba, kuma baka ɓata ma kotu lokaci wajen ɗaukar lokaci wajen yin shari'a ba. Wanda ya gaya wa kotu kenan.
Does he have anything to tell the court in allocators?
As the court pleases. Akwai wani alfarma da za ka roƙa wajen kotu yanzu haka?
Ina neman alfarma ne.
Ka yi magana sosai kotu ta ji ka.
Ina neman alfarma saboda ni mara ne kuma uwata ne ke ciyar da su mama. Ina da mata da yara.
Yes.
Sai me kuma?
Ina da ƙanne. Babu.
Ka daga murya ji.
Ina da ƙanne kuma babu wanda ke kula da su, sai ni kaɗai ne.
Sai me kuma?
Za ka ban san halin da suke ciki ba, sai ga musu Allah.
Baka san
halin da suke ciki ba.
ko wani abu da za ka kara?
Ina neman kokin alfarma ta mutu sace.
What does he do with this exhibit? Does he smoke or does he sell?
Me kake yi da wannan wiwi? Sha kake ko sayarwa?
Ina sha, amma kuma ban taɓa sai da shi ba. Sai wannan karar ina zuwa kuma na dawo da gurin aiki. Ina ya ƙare ko kuma ta zauna ba saboda ni ke cire.
I can't hear him.
Ba a jin ka fa.
Ina zaune ne ba na wani aiki kawai, na dawo da tafiya ne. Kuɗin da ke ciki na kusa ƙarewa, shi ne wannan katon da direba sai na siya a wajen saboda shi ma ba shi.
The review of facts done, this honorable court shall convict shall sentence the convict shortly.
As the court pleases.
Sentence. On the 10th day of July 2023, the defendant herein was adjudged guilty of the indictment in the charge sheet dated 5th June 2023 and filed on the 19th day of June 2023 based on a plea of guilty, which he entered when he was arraigned before this court on 10th day of July 2023.
As court pleases.
In the final analysis, the convict is hereby sentenced to 6 months imprisonment. The sentence shall be deemed to have commenced from the 8th day of May when he was arrested by a team of NDLA officers at Duan Joint along Potiskum Expressway, Potiskum, Yobe State, within the jurisdiction of this court.
As court pleases.
The seized drugs, being cannabis sativa, admitted as exhibits, which weigh 800 grams, is hereby confiscated and shall be forfeited to the federal government of Nigeria. This shall be the court sentence of the convict, which I deferred till today in order to reflect deeply on the appropriate sentence. The sentence is no doubt very light. It was deliberately made so in order to encourage the convict to quickly retrace his steps and return his family, particularly his mother. The convict may not be so lucky if in future he's caught and charged for a similar offense. This shall be the court sentence.
As the court pleases. Umar, a takaice wannan laifi da ka aikata kotu ta ɗaure ka wata 6. Zai fara kuma daga ranar 8 ga watan 5 na shekarar nan da muke ciki. Kotu ta yi maka sassauci wajen wannan hukunci sosai, kasancewa kai ne kake ɗauke da ɗawainiyan gidanku da kuma iyaye da kake tare da su da iyali. Saboda haka kotu ta umarce ka dawo mutumin kirki, ka canza halinka, ka zama mutum nagari, ka yi abin da zai taimake ka a rayuwa. In aka yi rashin dace ka sake aikata makamancin irin wannan laifi aka kama ka, to kotu ko ba ta da mafita sai dai kawai ta yanke ma hukuncin da doka ya tanadar, wanda kaɗan daga ciki shine ɗauri shekara 15, mafi yawa kuma shekara 25. So ka canja halinka. Sai ka zo.
Thank you, Malam Mustafa. Call the next case.
As the court pleases.
Charge number FSC/DM/CR/24 2023 between Babangida Chindo, FRN versus Babangida Chindo, Federal Republic of Nigeria versus Babangida Chindo.
Yes, my lord. The defendant is here present at the Correctional Center, Potiskum, my lord.
Respectfully, my lord, Usman Bamara, my humble appearance is for the complainant. My lord, the matter is fixed today for review of fact, and we are ready, my lord, subject to the convenience of my lord. My lord, I intend to prove the fact of this case through the exhibit officer, Mr. Muhammad Rabiu Suleiman.
Yes.
Mr. Muhammad Rabiu, please tell this honorable court once again your name, what you do for a living, and your rank.
My name is Mohammed Rabiu Suleiman.
And further state your schedules of duties and what do you know about this case? Very precise as the defendant has pleaded guilty in the matter.
Yes, my lord, PW1 is here present with us at the Correctional Center, and he is already on oath at the previous cases, my lord. Thank you.
My name is Mohammed Rabiu Suleiman. I work with the National Drug Law Enforcement Agency, Global State Command. My schedule of duties are receiving of exhibit and the suspect, carrying out a field test on the exhibit recovered from the suspect, weighing of the exhibits, issuing of exhibit forms, scientific for the suspect to thumbprint, witness and arresting officer to sign, and any other ad hoc duties given to me by my commanding officer. I know the defendant on the 9th of May, 2023. The defendant was brought before me
Yes.
by Mohammed Abdul Malik and Abdullahi Abu Bakr Ahmed. Along with a bako bag. I asked the defendant who owns this bag, and he said that it belongs to him. And when I opened the bako bag, I discovered there are some dried leaves suspected to be cannabis sativa and some drugs suspected to be psychotropics.
Yes.
I informed him that I want to carry out a field test, and he said yes. And the test proved positive for cannabis sativa, weighing 800 grams. And
Yes.
the drug identified as tramadol was proof positive for psychoactive substances. Weighing 4 grams.
Yes.
I bring out some exhibit forms, namely certificate of test analysis, packaging of substance form, request for scientific aids. I filled the necessary columns. Witnessing and arresting officer also filled their columns, and the defendant thumbprints on them.
Yes.
I took some part of the dry wheat and the tramadol and sealed it inside a white evidence transparent pouch, which I will be taking it to Lagos for forensic analysis. And
wannan shine mai bada shaida a kanka. A gane shi nan Rabiu Suleiman, Muhammad Rabiu Suleiman. Yanzu ya gaya ma kotu aikinsa da kuma dukkan ainihin yadda aka yi aka kawo ka wurinsa da kuma wasu takardu da ya ciccike lokacin da ainihin aka kama ka har kai ma ka sa hannu a kai da kuma kayan zargi da aka kama ka da shi duk bayanan da ya yi wa kotu kenan.
And the bulk of the exhibit was kept in an exhibit room for safekeeping. That's all, my lord.
Mr. Muhammad Rabiu Suleiman.
Yes, my lord.
In the course of your testimony before this honorable court, you stated that you filled some exhibit forms. Yes, my lord. Maybe the defendant also thumbprinted on it.
Yes, my lord.
And so also you kept the bulk of exhibit for safekeeping.
Yes, my lord.
Tell this honorable court how you will be able to identify the safe forms and the bulk of exhibit.
In both of the documents, my name was written there, my signature, my rank, and the date of documentation. And in the bulk of the exhibit, the NDLA case file number was also written there.
My lord, we apply to show the witness the said exhibit forms, my lord, for identification, my lord.
Yes, go ahead.
Yes, my lord, they are done.
My lord, we apply for the witness to bring forth the said bulk of exhibit for identification.
Yes, go ahead.
But we apply for the witness to open the said sack for identification, but to ascertain what it contains.
Yes, go ahead. Application granted.
My lord, these are the bulk of the exhibit. One is half block, wrapped in a yellow.
Mr. Nuhu, can you mute your device? You are interrupting proceedings. Yes, Correctional Center.
Yes, my lord.
Yes, you are saying. You say this is the bulk. Yes.
Yes, it's in half block, wrapped with a yellow leather, covered with a white sellotape, and the loose quantity.
That's not video my request.
And this is the tramadol tablet.
Mr. Nuhu Baba Umar, I said switch off your, mute your device. Witness, the exhibit officer.
Yes,
he
my
says
lord.
you have a half block wrapped in brown paper. Is it brown or yellow paper?
Yellow nylon, my lord.
Okay.
And some loose quantity inside a black polythene leather.
Okay.
And one cut of tramadol capsule.
That actually. Tramadol tablets or capsules?
Capsule, my lord.
Okay, what is written on the number?
NDLA stroke YBSC stroke 012 stroke 2023.
Yes.
My lord, in the circumstances, we sought to tender the certificate of the test analysis, packing of the substance form, a request for scientific aid, and the bulk of exhibit in evidence before this honorable court.
The tramadol, how many sachets?
1 sachet, my lord.
1 sachet, okay. The following exhibits are hereby admitted into evidence. The certificate of test analysis form, packing of substance form, request for scientific aid form, marked as NDLEA Babangida 1A, 1B, and 1C. The bulk of the exhibit of half block wrapped in yellow nylon with some loose quantity in black polythene, and 1 sachet of tramadol capsule, marked as NDLEA Babangida 2.
My lord, we equally sought to tender the statement, the voluntary statement of the defendant, both Hausa and English version, in evidence before this honorable court.
The extrajudicial statement of the defendant in Hausa language and the translated version in English language is hereby marked as NDLEA Babangida 3A and 3B respectively.
My lord, that's all for examination in chief.
Ask the defendant whether he has any questions to ask the exhibit officer.
As the court pleases. Babangida, akwai tambayan da za ka yi wanda ya bada shaida a kanka wannan? Ka bude murya ji. Babu. He has no question to the witness.
Show the defendants the exhibit and ask him whether this were the exhibits recovered from his possession when he was arrested.
As the court pleases. Wannan takardu da aka ciccika a dangwala hannu da kuma wannan jawabinka da aka rubuta da kuma wannan wiwi da aka kama a wajenka da asalin tramadol a ciki su ne wanda aka samu a wajenka da wayannan takardun duka su ne? He admitted, my lord.
Ask the defendant whether the facts are stated by the prosecution and the exhibits as presented by the exhibit keeper, as well as the statement, reflect the true position of the case.
As the court pleases, wannan shaidu da aka gabatar abin da ya shafi takardu da wannan wiwi da kuma tramadol da aka kama a gunka da shaida da wannan Muhammad Rabiu ya bayar duka sun tabbatar da gaskiyan wannan shari'a naka da ake yi a wannan wajen? Eh? Yeah, admitted, my lord.
My lord, that's all for the review of fact through the exhibit officer, and we apply for the witness for the exhibit officer to be discharged from the witness box.
Application granted. Thank you, officer.
Thank you, my lord.
Ask whether the defendant has any cause to show why he should not be convicted as charged.
As the court pleases. Babangida, kana da wani hujja ne wanda zai hana kotu ta yi maka hukunci? Babu hujja.
The defendant who on arraignment pleaded guilty to the charge dated 5th June 2023 and filed 19th day of June 2023 has not produced any evidence of lawful possession of exhibits Babangida 2. I'm satisfied against his plea of guilty and tested proof of exhibits Babangida 2 that the case against the defendant has been proved beyond reasonable doubt as is required by sections 137 and 138 of the Evidence Act 2011. In view of the plea of guilty entered by the defendant and in line with the provisions of sections 2741 and 2 and sections 3561 and 2 of the Administration of Criminal Justice Act 2015, this court hereby finds the defendant, Babangida Chindo, guilty of knowingly without lawful authority dealing in cannabis sativa, and thereby committed an offense contrary to and punishable under section 11 of the 19 of the NDLEA Act, Cap N30 laws of the Federation of Nigeria. The defendant, Babangida Chindo, is hereby found guilty and convicted as charged. I shall listen to the allocators of the convicts before I pronounce on his sentence. This shall be the judgment of this court on the basis of the charge dated 5th June 2023 and filed 19th June 2023.
As the court pleases. Babangida, duba da hujjoji da shi mai gabatar da kara ya gabatar a gaban wannan kotu, daga ƙarshe kotu ta gamsu cewa ka aikata wannan laifi, saboda haka yanzu kotu ta same ka da laifi. Shine abin da kotu ta faɗi.
Any record of previous conviction?
My lord, the convict has no previous record of conviction. He is a first-time offender. He did not grace this court, my lord.
Yes, go ahead.
My lord, that's all, my lord. Thank you very much.
Shi mai gabatar da kara kotu ta tambaye shi cewa ka taba aikata laifi makamancin irin wannan, yace baka taba aikata laifi irin wannan an kama ka ba, kuma baka ba su wahala wajen bincike ba. Shine abin da ya faɗi ma kotu.
Does he have anything to say to the court? Allocators.
As the court pleases, akwai wani alfarma da zaka roƙa wajen wannan kotu? Kai magana sosai kotu ta ji, ka kalli kotu kuma. Ka bude murya sosai.
Na da iyaye guda uku. Babana bai da lafiya, ni nake
Yes.
Babana bai da lafiya, ni nake ɗan taimaka.
Ka yi magana a jika.
Ni nake taimaka zuwa abinci a gida.
Yes.
Ci gaba an akwai ne.
Ina roƙon alfarmar da kotu ta sassauta mun duba mu gaba laifin da na aikata.
What the exhibits found in your possession, what were you doing with the exhibits? Are you selling them or do you smoke them?
Wannan wiwi da aka kama da wurinka, kana sha ne ko kana sayarwa?
Ina sha kuma ina sayarwa.
Kana sha kuma kana sayarwa?
This honorable court will sentence the convict shortly.
As the court pleases.
Sentence.
As the court pleases.
On the 10th day of July 2023, the defendant hearing was adjudged guilty of the indictment in the charge sheet dated 5th June 2023, filed on the 19th day of June 2023, based on a plea of guilty which he entered when he was arraigned before this court on the 10th day of July 2023. The sentence was deferred till today to enable me to have a deeper reflection on the appropriate sentence, which will meet the justice of his case. In criminal jurisprudence, the two broad goals of judicial sentencing are firstly to seek the reform of the convict so that by the time he completes the penal custodial sentence, which the court imposes, he will return to the society as a better and more responsible citizen who strong arm of the law, who are also involved in similar acts for which the convict is being punished. While the first goal focuses on the convicts in the dock, the second goal, in my view, focuses on both the convicts in the dock and the society at large, especially for persons who are or may be involved in similar criminal activity for which the convict is being sentenced. In the final analysis, the convict is hereby sentenced to 6 months imprisonment. The sentence shall be deemed to have commenced from the 9th day of May 2023, when he was arrested by a team of NDLA officers at Kiayo Dawasa in Nangare, Yobe State, within the jurisdiction of this court. The seized drugs being cannabis sativa admitted as exhibits, NDLEA Babangida 2, which weighed 800 grams, and the tramadol capsules is hereby confiscated and shall be forfeited to the federal government of Nigeria. The said exhibits, NDLEA Babangida, shall be destroyed by burning by the NDLEA, along with other judicially condemned narcotics and psychotropic substances at a public function to be organized by the NDLEA. This shall be the court sentence of the convict, which I deferred till today. The sentence is no doubt very light. It was deliberately made so in order to encourage the convict to quickly retrace his steps and return to his family. The convict may not be so lucky if in the future, if he is caught and charged for a similar offense. Yes, go ahead.
Takaice laifi da ka aikata kotu ta ɗaure ka wata 6. Ɗaurin nan kuma zai fara daga ranar 9 ga watan 5 wanda ya gabata na wannan shekara. Sannan a yanayi na shari'a, dalilin da ya sa kotuna suke hukunta masu laifi dalilai biyu ne. Dalili na farko, saboda mai laifi ya canja halinsa da ɗabi'unsa ya dawo mutumin kirki. Dalili na biyu kuma ya shafi shi wanda aka hukunta da ma waɗanda ba a kama su suna aikata makamancin irin wannan laifi ba, saboda ya zame musu izina kada su ci gaba da yin wannan abu inda ba a kama su ba. A takaice kuma kotu ta baka shawara, tana umartanka kada ka yadda a sake kama ka karo na biyu kana aikata irin wannan laifi, saboda in aka kama ka karo na biyu kaɗan daga cikin ɗaurin da doka ya tanadar shekara 15, mafi yawa kuma shekara 25. Saboda haka kotu ta umarce ka da ka dawo mutumin kirki ka canja halinka bayan zaman ka cikin.
Thank you, ma'am. Please call the next case. Registry of Court. Federal High Court, Damaturu. Are still there?
Sorry, my lord, if they are offline, may I call the case here at the correctional
Yes, go ahead.
as the court pleases. Charge number FSC DMCR/19/2022 between the Federal Republic of Nigeria versus Sani Awal and one order. Sani Awal and one order.
Respectfully, my lord, my name is Usman Bamada, my humble appearance for the complainant.
May I please, my lord? Hello?
Yes, go ahead.
May I please, my lord? My name is NB Umar, and my appearance for the dependent, my lord. Sorry, my lord, we have been experiencing a lot of challenges here in Damaturu, my lord. I don't know whether the Federal High Court Damaturu are together with the accused person or with the dependents now.
Registry of Court. Registry of Court.
Problem. Yes, we are having a problem with the network here in Damaturu, my lord.
Okay. Notwithstanding, yes. Counsel.
Yes, my lord.
Yes, I'm waiting for you before they rejoin us. Yes.
Yes, my lord. The matter is slated today for the for judgment in respect of plea again, my lord.
Having perused the court file, is the prosecution there? Can you hear me?
Yes, my lord, I can hear the court, madam.
Okay, the defendant's counsel.
Yes, my lord, I can hear you.
Okay. The challenge I have here, after perusing the file, I noticed that the plea bargain agreement has not been endorsed. It has not been signed by anybody. The one in the court file, which is supposed to be the original document, has not been signed by counsel or by the convicts.
Sorry, my lord. The one I have here, it has been signed, my lord. I don't know what happened with the one that is filed at the registry, but the one that I have here is signed.
Prosecution counsel, your own copy has
my own copy too is signed, my lord, and duly completed by the defendants.
The one in the court file I've confirmed has not been signed. Can you do what is needed to be done before tomorrow? Tomorrow, then.
Yes, the one with us, my lord, it has not been signed, my lord.
It has not been signed. Yeah. Okay. This is a registry of court, Damaturu.
Not dated.
Not dated.
It has been signed, but not dated.
The ones in the okay. Counsel, can you hear me?
Yes, I can hear you, my lord.
Yes, I think the The ones for the court, I need it to be dated, to be signed and printed, whatever. So I think this matter should be adjourned to tomorrow.
That's court, please.
Prosecuting counsel, are you still there?
My lord, yes, my lord. We hold no objection, my lord.
Okay. Matter adjourned to tomorrow for the plea by again agreement to be incorporated as the judgment of court.
That's court, please.
Please, counsel, endeavor to see that it's signed and dated before then.
Thank you, my lord. I will do so. Thank you, my lord.
Thank you.
Thank
Yes,
you.
please call the next case.
Next case. Charge number FSC/DM/CR/5/2022 between the Federal Republic of Nigeria and Musa Ahmed.
And okay, Mr. Indahi, registry.
Yes, my lord. Yes, my lord.
Explain to them the reason why this matter has been adjourned to tomorrow.
As the court please.
Yes. Which case has been called now? Is Indahi there?
Ahmed, CR5.
Okay, Musa Ahmed.
CR5, yes, my lord.
Okay.
Defendant is not here, my lord. Defendant not in court, my lord.
Yes, my lord. The defendant is here present at the correctional center, my lord.
Thank you.
Thank you, my lord.
Respectfully, my lord, Usman Bamara, my humble appearance is for the complainant. My lord, the matter is fixed today for continuation of hearing, and counsel to the defendant is not available before this honorable court.
Yes, I'm trying to open the file.
Pastor, please.
Okay. Yes, counsel, you can go ahead.
My lord, the matter is fixed today for continuation of hearing.
Yes.
And counsel to the defendant is not available before this honorable court.
Yes.
My lord, in the interest of justice and fair play, we will be asking for a date, my lord.
Registrar of court.
Yes, my lord. I'm sorry, my lord.
No, I wanted to be suggest a date. Give me a date.
18th October, my lord, after vacation. 18th October.
Okay. October.
Yes, my lord. Yes.
Okay. This instant matter was slated for continuation of hearing was called. The defendant is before the court, but his counsel is absent, his representation. The prosecuting counsel applied for an adjournment. This honorable court Everyone listen to the application, hereby granting is going to continue to be incarcerated. Correctional Center, can you hear me?
Yes, my lord. An kira wannan case naka.
Matter adjourned. Okay, thank you.
Aka kira lauya mai kare ka baya nan. So shi mai gabatar da kara ya nemi kotu a daga wannan shari'a naka zuwa ranar 18 ga watan 10. An riga an daga karanka nan zuwa ranar 18 ga watan 10. Ka je ka zo nan.
What does he wanted to say something?
Okay, so ka ce.
Yeah, an same ni da kayan nan hajiya.
Me ne kake so a faɗa?
An same ni da kayan nan, an kama ni da shi.
Maybe at the next adjourned date, maybe. Yes.
Ranar da aka daga case din za a ji wannan maganar naka. Je ka zo.
Yes, call the next case.
As the court please. Charge number FSC/DM, charge numbers FSC/DM/M/43/2023 between the Federal Republic of Nigeria and Adamu Sani and one another.
Adamu Sani ne da ya dependent.
It's a motion, my lord.
Hamza Muhammad.
Okay.
Adamu Sani da Hamza Muhammad Maina. Adamu Sani da Hamza Muhammad Maina. Yes, my lord.
Yes, representation. Yes.
Are present at the correctional center, my lord.
My lord, with the greatest respect and humility, SM also is my name. My respectful appearance is for the defendants, applicants.
Respectfully, my lord, my name is Usman Bamala. My humble appearance is for the respondent, my lord, complainant.
Yes.
Well, my lord, before your lordship is a bail application in favor of the defendants. Dated and filed on the 14th day of July 2023.
Just a minute. Dated
14th day of July.
Yes.
2023 and filed on the same date.
Yes.
Subject to your lordship convenience and my learned friend, I apply to move the motion.
Yes. Go ahead, counsel.
Thank you, my lord. My lord, this is a motion on notice. Brought pursuant to section 35 sub 1 and 36 of 5 of the 1999 Constitution of the Federal Republic of Nigeria as amended, and sections 158 and 162 of AGJA 2015, and under the inherent powers and jurisdiction of the court.
Go ahead.
My lord, the motion prays this honorable court to graciously admit the defendants and applicants to bail pending the determination of charge number FHC/DM/CR/28/2023 2023 filed against them before this honorable court. And then the omnibus prayer, my lord. In support of the motion, my lord, is an 8-paragraph affidavit deposed to by Abubakar Nasser of SM also and Co.
Council, can you move in terms? We have so many cases and we have been sitting here all morning.
Thank you, my lord. Thank you, my lord. We respectfully move this motion in terms of the motion papers and urge my lord to respectfully grant them in the interest of justice, particularly having regards to paragraph 4D. We respectfully urge my lord to grant this application in the interest of justice. Thank you, my lord.
Wannan shine lauyan ku da yake nema muku beli yanzu. Barrister SM Al-Sukun.
My lord, we hold no objection, my lord, as we consider the application.
Shi ma lauya mai gabatar da kara ya ce baya da ja, ya aminta kotu ta ba da ainihin beli. Mun gode.
This case was called the defendants before the court. The letter of counsel to the defendants applied for the bail of the defendants. The prosecuting counsel is not opposing. This honorable court, having listened to the application and submissions of counsel, will deliver a ruling shortly.
We agree. We agree.
The defendants in this case are Musani and Hamza Mohammed, who are standing trial before this court on a 2-count charge dated on 7th July 2023. The defendants pleaded not guilty to the charge when they were arraigned. Trial is yet to commence. The defendants applicants through their counsel file a motion on notice. By the motion on notice, the defendant prays for the court to admit the applicants on bail pending the determination of the case against them. In support of the prayer is an 8-paragraph affidavit deposed to by one Abubakar Nasir, a litigation secretary in the law firm of the applicant's counsel. I'll skip the submissions of counsel. It is significant to emphasize that the recognition of bail, even though very needful constitutional as it is, the entitlement is, however, not absolute. As a matter of course, an applicant counsel have considered the fact that the granting of bail is discretionary and cited authorities to portray their point that discretion must be exercised judicially and judiciously. Whilst the jurisdiction of the court exercises in bail applications is required to be so exercised liberally in order to give effect to the provisions and spirit of the Constitution, in particular, its section 36 sub 5, by which an accused person is presumed innocent until the contrary is established. The court is often concerned with one major issue in the guidelines. It is the prospect of the defendants returning to face their trial, where the hope is dim and there are no materials placed before the court to assuage the fear of the state that the defendants will be available to face their trial. The court in deserving cases, even for such indictments as in this case, will ex debito justitiae refuse to exercise his discretion in granting bail. I know the provisions of, like I stated, section 35(4)(1)(4)(5), section 36 sub 5 of the Constitution, and section 165(1) of the Administration of Criminal Justice Act 2015 provides that granting of bail to the defendant who is standing trial shall be at the discretion of court with due regard to the circumstances of the case, and enjoins that bail conditions shall not be excessive. In the instant case, I am cautious in granting bail to the defendant as a reason for the judicial and judicious exercise of discretion by the trial court is subject to the fulfillment of the condition that the defendant applicants will not jeopardize their trial for whatever reasons. By the provisions of Section 35-36 of the 1999 Constitution, the courts will always want to exercise their discretion in favor of granting rather than refusing bail to a defendant accused of committing an offense, which is not a capital offense. What the court requires is not for the defendants to evade their trial, but for the attendance of the defendants in court. Consequently, bail is granted to the applicant defendants, one, in the sum of 3 million naira each and 2 sureties, each in the like sum. 2, the first surety must be a traditional or religious leader in Yobe State within the jurisdiction of this court. 3, the second surety must be a responsible person, member of the society from any sector. 4, the 2 sureties to stand for each of the defendants must be resident in any of the local government capitals of Yobe State. And that fact must be verified by the NDLEA as reliable. The 2 sureties shall each swear to an affidavit of means. 6, the defendant applicant together with both sureties must each deposit 2 copies of their passport, recent passport photograph with the station registrar of this court. 7, the defense counsel shall write a formal letter excuse me, to the station registrar, Federal High Court, Damaturu, to introduce the respective sureties as responsible citizens to whom the court can safely release the defendants on bail pending their trial, and aid the defendant to provide a valid active bank account that has an attached BVN number. This fact must be verified by the defendant's counsel as having been complied with before the release of the applicants on bail. The application succeeds on the terms and conditions as prescribed. Meanwhile, the defendants are to be remanded in the Potiskum Correctional Center until they fulfill the bail conditions.
My Lord, we are grateful. We are much grateful, my Lord.
Welcome.
Thank you.
The registry of courts, can you give us a date?
Sorry, my lord. I'm afraid. I think the defendants pleaded guilty the first day of arraignment. So the case was adjourned for review of fact.
Okay. The counsel, both counsel did not allow the court to such development.
And my Lord, that was the position of paragraph 4D. They intend to change their plea, but my Lord was ruling we don't have to interrupt. We stated it in the affidavit.
That's why you are supposed to, because as far as I'm concerned, okay, they wanted to change their plea.
Yeah, my lords. But they have not been convicted, so the ruling of my lord is apt. We have no, on the date they are coming back, they have been already given a date. On that day, their charge may be read to them for the lordship convenience.
The prosecution counsel, are you there?
My lord.
Yes, what is your response?
My lord. Yes, my lord. Ordinarily, my lord, considering the nature of the application, we could have filed our own counter. But however, my lord, I was briefed by the counsel to the defendant, who informed me that his service has been engaged and they intend to undergo a full trial with us. So therefore, my lord, so that's the reason why we allow them to reconsider the application, my lord. That they intend to change their plea in the next adjourned date. So I thought, my lord, in the course of addressing this honorable court when moving the application, the court will be informed.
Court, give me a date.
Thank you, my lord. The case was adjourned to.
My lord, the court has adjourned the matter to 17th day of October.
Oh, I see.
Thank you.
Okay.
Although the last agenda was for review of fact, but we will, my lord, apply to commence hearing on that very day, my lord, to present our witnesses, my lord.
Thank you. The matter is hereby adjourned to the 17th day of October 2023 for commencement of hearing.
We are grateful. We are much grateful.
Please call the next case. Registry of Court, are you still there?
Yes, my lord. Motion number FSC/DM/M/44/2023 between the Federal Republic of Nigeria and Abubakar Musa.
Yes, my lord, the defendant is here present at the correctional center, my lord, Fortescue.
Respectfully, my lord, Usman Bamala,
Hello, my lord.
Yes.
May it please this honorable court, my lord, MB Ngohi, my humble and respected appearance is for the defendant applicant, my lord.
Respectfully, my lord, Usman Bamala, my humble appearance is for the respondent, but not complainant.
Yes.
Yes, my lord. We have a bail application via motion on notice. Before you subject your convenience, I'm ready to move the application, my lord. Hello, my lord.
I can, yes. I don't want the same mistake repeated.
Okay, my lord.
Although this is for the, okay. Let's go.
Yes, my lord. It's the same thing, my lord.
Yes, okay, actually. Yes, counsel, go ahead.
Yes, my lord. The motion before you was dated 14 July 2023 and filed on 17 July 2023, my lord. My lord, the motion is brought pursuant to section 158 and 165 of the Administration of Criminal Justice Act 2015.
Move in terms, counsel. The day is.
Please, my lord.
Yes.
Yes, my lord, since the respondent did not file a counter, we humbly apply to move the application in terms of the motion paper.
Go ahead.
My lord, attached to this application is 9-paragraph affidavit deposed by Abdullahi Ibrahim Gambo, a litigation secretary from Amburu Chambers. My lord, in compliance with the rules of the court, annexed to this application my lord, is affidavit in support of motion. No, sorry, my lord. is a written address in support of the motion for bail, my lord.
Counsel, you are wasting my time.
Sorry, my lord. And we humbly apply, my lord, to grant our application, to grant our prayers contained in the application. May it please this honorable court, my lord.
Thank you, counsel. Any response?
My lord, we hold no objection to the application, my lord.
This case was called. The defendant is in court. Counsel to the defendant applied for the bail of the defendant. The prosecuting counsel is not opposing. This honorable court, having listened to the application and submissions of counsel, will deliver a ruling shortly. Bench ruling. The defendant in this case is Abubakar Musa, who is standing trial before this court on a one-count charge filed by the National Drug Law Enforcement Agency. The defendant pleaded guilty to the charge when he was arraigned before this court. The defendant, through his counsel, filed a motion on notice, praying this honorable court to admit the applicant on bail, pending the determination of this charge against him. There's a written address of counsel of the defendant applicant. I'll keep the submissions of counsel, the written address. Counsel urges the court to exercise its discretion in favor of the applicant and grant the relief sought in the best interest of justice. The prosecuting counsel, in response to the application for bail submitted orally, that they are not opposing the application. In determining this application, I've considered the submissions of counsel, the affidavit filed in respect of the application, the authorities cited and relied upon, consisting of statutory and case law. It is significant to emphasize that the recognition of bail, even though very neutral constitutionally as it is, the entitlement is, however, not absolute. As a matter of course, and applicant counsel have considered the fact that the granting of bail is discretionary and cited authorities to buttress their point that discretion must be exercised judicially and judiciously. A court of law is created to settle disputes between parties who come to it for litigation, whether in civil or criminal matters. It is not the aim of a court to punish a litigant before finding him liable or guilty of the claim or charge made against him. Bail is meant to procure the release of one charged with an offense, ensuring his future attendance in court and compelling him to remain within jurisdiction of court. It literally means to set at liberty a person arrested or imprisoned on security being taken for his appearance on a day and place certain. By the provisions of Section 35 and 36 of the 1999 Constitution of the Federal Republic of Nigeria, the courts will always want to exercise their discretion in favor of granting rather than refusing bail to a defendant accused of committing an offense, which is not a capital offense. What the court requires is not for the defendant to evade his trial, but for the attendance of the defendant in court. Consequently, bail is granted to the applicant defendant, one, in the sum of 3 million naira and 2 sureties in the like sum. 2, the first surety must be a traditional or religious leader in Yobe State. 3, the second surety must be a responsible member of the society from any sector. 4, the 2 sureties to stand for the defendant must be resident in any of the local government capitals of Yobe State, and that fact must be verified by the NDLEA as reliable. 5, the two sureties shall each swear to an affidavit of May 6. The defendant applicant, together with both sureties, must each deposit 2 copies of their recent passport photographs with the station registrar of this court. 7, the defense counsel shall write a letter to the station registrar, Federal High Court, Damaturu, to introduce the respective sureties as responsible citizens to whom the court can safely release the defendant on bail pending his trial. 8, the defendant is to provide a valid bank account that has an attached BVN number. This fact must be verified by the defendant's counsel as having been complied with before the release of the applicant on bail. The application succeeds on the terms and conditions as prescribed. Meanwhile, the defendant is to be remanded in Potiskum Correctional Center until he fulfills the bail conditions. The matter is hereby adjourned to the 8th day of October, 2023.
I'm very much grateful, my lord.
You're welcome. Yes, call the next case.
That is all, my
that is it for the day?
That's all, my lord.
Okay. Thank you so much, Malam Saliu, and the correctional, Potiskum Correctional Center. Thank you so much.
Thank you very much.
Okay, you're welcome. The prosecuting as well as defense counsel that have appeared before this court this morning, thank you so much.
Thank you.
Federal High Court Damaturu, Registry of Courts, thank you so much for your assistance. And I wish everybody a blessed day.
Thank you, my lord.
Okay, thank you. See you tomorrow, inshallah.
Thank you, my lord.